And we're going to start today. We left each other last week in the throes of working with sellers. And we're going to start today with looking specifically at the most commonly used listing agreement. So this is our exclusive right to sell. And remember, with the exclusive right to sell listing agreement, specifically, just to sum this up, I get paid no matter where the buyer comes from. If I bring the buyer, I get paid. If another broker brings the buyer, I get paid. If the buyer shows up unrepresented, I get paid. If the seller brings the buyer, oh yeah, I get paid. So this is the best one for the firms to protect their commission when working with sellers. I'm going to say this is the listing agreement that is used the most common. Again, please don't ever get it stuck in your mind that the pre-printed forms that we look at in pre-licensing, post-licensing, CE throughout your career, these pre-printed forms that we look at are not the only ones that we're allowed to use. The reason we're looking at these is because they are the most commonly used, in this case, listing agreement. So we're going to go through this awfully similar like we did with our buyer's agency agreement. Again, not word for word, but there are testable points in this. So I would use this as an additional, again, like our buyer's agency agreement, kind of use this as an additional study point. Again, you guys don't have to memorize this thing, but we need a general understanding of what's in here. So right out the gate, it tells me this agreement is between the seller and who? The seller and the firm. The relationship, the agency agreement is between the client and the firm. Services provided, we have to spell out our duties. We have to spell out our responsibilities. So seller hires the firm as an exclusive agent to help sell the property. Seller agrees to cooperate with firm and agrees that all leads, prospective buyers, marketing, offers, negotiations, contracts, inspections, etc., will be facilitated by and through the firm only. So seller, when somebody wants to buy your house, don't try to sell your house. That's why you hired me. If somebody reaches out to you, if somebody comes to you directly, they know their address, right? And guys, we've talked about a couple years ago how it was a crazy, crazy seller's market. Buyers were desperate. Y'all, there were buyers walking up to the seller's front door and ringing the doorbell and saying, please sell your house to me. So in those cases, we just kind of, those extreme markets, we need to prepare our sellers. But either way, no matter how they might talk to a prospective buyer, they need to refer them to us. And that's why they hire us, is to help with their negotiations, inspections, etc. Firm will act in the best interest of the seller. Firm may assign other agents to provide services at any time. Terms of the agreement, remember one of our musts, one of our 4 musts of a written agency agreement is we have to have a definite end date. And so our exclusive right to sell listing agreement says this thing will expire at 11:59 p.m. on this date. That means I owe you agency until 11:59 on this date. At the stroke of midnight, we're done. We're going to talk today about what happens when these agency or different ways that these agency agreements can end and what happens to those duties. So we're going to talk about termination today. And then we got to describe the property. What is the property that we are about to list? So we start with the street address, and then we also have some of the legal descriptions. So there's your block or section, subdivision, deed, book, and page. Again, as you're doing the research, as you're gathering this information to prepare for the listing, this is stuff that comes up in your search, that GIS search that we mentioned. So we just want as much of the legal description as we can. This information often translates onto the offer to purchase and contract. And the attorney looks at the contract, make sure we're talking about the same property. Everybody wants to make sure we're talking about the same property. So by defining the legal description the best that we can, it makes sure we're all on the same page. Then we look at a list of fixtures with the sellers. Now, when we get to Unit 8, we're going to look at our sales contract. And when we look at our sales contract, we're going to see this exact same list of fixtures, word for word, shows up in the contract. The reason it's in the listing agreement is so we can have these conversations with the seller now. is there anything on this list you plan on take? Or is there anything that you would define as a fixture? Maybe not on this list, but it's permanently attached in a way that is meant to stay. And if the seller wants to take anything, that's great. That's great. We just need to talk about how that's going to happen. Are you going to take it down now and replace and repair? Are you going to take it down when you move? If you take it down when you move, listing agents, you have a duty to make sure all prospective buyers know that when they buy this house, this fixture won't be included. It will not convey. Also, listing agents, when that offer comes in, you need to make sure that that fixture is excluded in the offer to purchase and contract. So this list enables us, it's like a starting off point for conversations. And it allows us to have the conversations with sellers about fixtures, if there's anything they want to take and what their intentions are. When do they plan to take it? And what do they plan to do with the space that was once where the fixture was? I can't tell y'all how many times I've been at a listing appointment. The seller looks at me and says, oh, okay, we'll look at this tonight before we go to bed. I know what that means. Y'all know what that means? They're never going to see this again. So I look at my sellers and say, you know what? I'm a very patient person. I can sit here for 4 minutes while you look this thing over. Everybody with me? Because the last thing you want is to have your seller move out and jerk something out the wall and then have the buyer terminate because the seller breached because they took that fixture that we didn't agree to. Remember, fixtures are meant to stay. And if they're going to do the opposite of their intent, then we need to make sure they're excluded in the contract. Can a person cover a pool and not be known where it is? You're talking about permanently cover, like fill in with cement kind of thing. As long as it's permanently covered, yeah. We may not know. We just see a slab out back. So can they? Yeah. As with our buyer's agency agreement, at the bottom of page 1, we have just a couple things. We saw our realtor letting people know that realtors can use this form, telling us the source of the form, the North Carolina Association of Realtors, the number, Standard Form 101, and then making sure we're looking at the current form, January 2025, and our Equal Housing Opportunity logo. By the way, before I forget, Learn Test Pass has updated the agency agreement. So our buyer's agency agreement, your listing agreement in the resources tab, and Learn Test Pass is up to date. And then I also have the current forms in Google Drive. I think the forms are a little bit easier to access in Google Drive because you could download them as a PDF, but that's just me. So I'm going to keep them in Google Drive because I think it's a little easier to access, but you guys can get it either from Google Drive or Learn Test Pass. The seller has a duty to unpair or delete data, any of their smart technology connected to the phone. The seller's got a duty to unpair or delete, set back to factory reset prior to settlement, prior to closing. We have an interesting note here that says the seller's duty will survive closing. So even if they forget to unpair or delete or set back to factory reset, after closing, that duty continues. So they forget, we may just need to get with the agents and remind them. Items leased or not owned. I think we've all agreed that you can't convey what's not yours. So if you lease but you don't own it yet, such as satellite dishes, appliance, solar panels, electric car chargers, and alarm systems, they need to be identified here and they will not convey. We talked about the Uniform Commercial Code, and the Uniform Commercial Code protects these items, things from a creditor that's been filed that is not yours yet. You don't own it until you make that last payment. So if it's something that the homeowner is making payments on, it might be that they just pay it off as part of their closing proceeds. It's going to show up as a lien. The closing attorney is going to find it. Or they just need to return it to whichever company. For example, if it's security systems, then CPI may want their equipment back, right? So we just need to have a conversation with the seller. And I've said this, and let me say it again. Being familiar with the listing agreement, this is your listing appointment right here. So this is our talking points through the listing appointment once we're with the seller. So being familiar with it allows us to have these conversations about items leased or not owned. C then is excluding items. So any fixtures that are going to go, they need to be identified here to make sure we're all on the same page. Any fixtures that are going to go need to be identified here. And then D, the seller's going to list any personal property that they would be willing to leave, such as the refrigerator, washer, dryer. And then we might get into lawn equipment or living room furniture or dining room suite, stuff like that. Remember, you guys, this is only the seller telling us what they would be willing to leave. There's no guarantee that a buyer wants this personal property item. It's all negotiable. So if the seller's willing to leave the fridge, and the buyer doesn't ask for the fridge in the offer, and you even call the seller's agent and say, the seller's willing to leave the fridge, doesn't your buyer want it? The seller's agent might say, or the selling agent might say, no, my buyers have their own fridge. They don't want this one. They don't have to take it just because the seller's willing to leave it. So again, we just need to have the conversation with the seller. I'll advertise that the fridge is going to remain, but if the buyer doesn't want it, it's still personal property, and you still need to make arrangements to get it out of here before closing. What do you do with it? I don't care. Just get it out of here because it's personal property, and personal property is meant to go unless agreed otherwise. Then we talk about the listing price. Remember, I'm not asking a client to sign an incomplete form anyway. Doesn't that just sound like a good rule of thumb? We're not asking clients to sign incomplete forms anyway, but specifically, they say, I cannot ask the seller to sign this without us agreeing to the listing price. So broker and seller need to agree what we're going to list the price for. And then the seller is going to accept payment from the buyer on the following terms. So they're going to list, do they want a cash buyer, FHA, VA, USDA, etc.? Is this a loan assumption, seller financing, other, etc.? We're going to talk about those different financing terms when we get to Unit 6, so please bear with me. But from right now, some sellers don't want to deal with lenders. They don't want a buyer to deal with lenders. So some sellers might say, I'll only accept cash only. We're going to learn when we get to Unit 6 that not all properties will qualify for FHA or VA loans. So it might just be that those aren't eligible for this home, eligible for this property. So again, it's just a conversation with the seller. By the way, we advertise this in MLS, acceptable financing terms. So any prospective buyers can see, ooh, this seller just wants cash only. I have to get a loan. This property isn't going to work for me. And then we're going to talk about marketing. Firm will use its best efforts to find a ready, willing, and able buyer. There's our three-legged stool again. Unless otherwise described below, buyer will begin marketing on this date. It's going to be really, really hard. I'm not saying impossible, but I'm going to say there's lots of challenges to try to get this thing signed today and get it on the market on the same day. Because once we enter into this listing agreement, we got a lot of work to do. Maybe the seller's got to paint something. At a minimum, you got to either measure or arrange for measurements. You got to take pictures or arrange for pictures. So we're going to agree to enter into this listing agreement today, but then we're also going to agree to what date it's actually going to go live. What date are we going to start marketing this property? What date is the public going to see it? And how long you give yourself. Is it 2 days or 2 weeks? The answer to that is, it just depends. It just depends on how much work both sides have to do before this thing is ready to go on the market. If you're paying somebody to do your pictures and measuring, you need to get with them because you don't know their schedule probably. So you need to make arrangements for them. And if you're working with somebody, you know kind of their timeline, you know their turnaround. So that helps as well. So we got to agree to a marketing date when this thing is going live. And then the seller authorizes the firm, and we got a couple options here. So I'm just going to highlight it at first so we can see the two options, and then we'll talk about each. So the seller authorizes the firm, no, that's not what I want, to go either public marketing or office exclusive. Public marketing says we're going to market to the public. We're going to put it in MLS. It's going to be fed to thousands of websites. The world is going to know that this home is for sale. We have advertised and marketed it to the public. An office exclusive means that this listing doesn't leave our four walls. And please note, you guys, that does not say firm exclusive. That says office exclusive. We cannot discuss this outside of our four walls, outside of underneath our roof. MLSs are pretty strict on this. So if you're going office exclusive, what that means is you can't talk to anybody about this listing except for your coworkers, except for the people in your office. The moment you talk to somebody outside, you've switched to public marketing and you got to make it available to everybody. A good example is of an office exclusive. I have a couple agents actually that are working with investors. And these investors are very specific about what they want. And so my teammates know when they get a potential listing to go to that agent first to see if it's something that their investor would be interested in. In that case, we pretty much just sold it without advertising, without marketing it, right? So examples like that, various things where you've kind of discussed the buyer and the seller, you've brought them together. The majority of the time, we do public marketing. And so if we go public marketing, we got a couple other things there to agree on. Are we going to do coming soon advertising? Just think of coming soon advertising as like a teaser. You guys know when they release a new movie and they give you a trailer to try to get you to go run out to the movie theater when it's released? That's pretty much what we're doing with coming soon. With coming soon, there's no showings allowed at all. We're only advertising it, we're only marketing, but nobody can see it when it's in coming soon status. And again, you need to have that conversation with your sellers, because what's stopping a buyer from showing up on the front porch and saying, hey, can I see it? So the sellers need to know that in coming soon status, I can't show it to anybody. It's a teaser, it's a trailer. We got to get the seller's permission to put a sign in the yard. Not everybody wants their nosy neighbors to know that their home is up for sale. Maybe for various reasons, they don't want the neighbors to know. They don't want that tacky sign in their front yard. So we got to get their permission to put a sign in the yard. Are we going to do an open house? And then just general advertising. This gives us permission to put it on the internet, to put this listing on the internet. If the seller doesn't want their listing on the internet, if they don't want the world to see where they sleep, then I got a form for them to opt out of internet advertising. And you got a big conversation to do now, right? Because if you're not going to advertise via internet, it's 2025. What's left, right? So you're going to have to be creative. Print media, flyers, right? Networking, lots of networking. But if you come across a seller that doesn't want their home online, and that does include social media, then I got a form for them to opt out. Or we go, like we said, we go office exclusive, in which we're only marketing and advertising it within our four walls, within our office. But MLS is okay. No, that's internet advertising. Yep, yep. They're saying that, and that's where, and everywhere you see a property for sale, Zillow, Realtor.com, CobbleBanker.com, all those sites all start from the MLS. We would probably, if that case, if they said no internet, we would discuss, or the buyer's agent would discuss with the buyer once they've become the owner about putting it at MLS for comp purposes only. So we can still use it for comps, but it's not being marketed, it's not being advertised. The marketplace is Facebook. Facebook is the internet. Social media, you guys, you know, you're not going to find a lot, but are there some out there that are anti-internet? And some days I am, I'm not going to lie. you know? And it's just really what it comes down to. They just don't want their personal life for the world to see. Oh, wow, this is where this person sleeps every night. You know, you get pretty dang personal, right? When you list somebody's home for sale. Other questions on marketing? We're going to get permission to put a lockbox on the property. They do or do not agree to put some kind of lockbox. There's combo boxes, there's super boxes, there's Century lock boxes. It just depends on which MLS you join. But there's some kind of lockbox. So again, we got to get their permission to put a lockbox on their property. Marketing risks. This is just letting the seller know that when we do market, when we do advertise, there are some risks. Unauthorized use of keys, for example. I can't control all the visitors of the property. You know, let the sellers know when they'll know when a showing's happening anyway, but they may want to put up things that can easily slip into a pocket. They may want to put up things of value. Sometimes buyers pretend to be buyers to go scope the place out and see if it's worth coming back and hitting later. So if your seller's advertising all their big expensive stuff, they could be setting themselves up. So having these conversations with the seller. What if a buyer sees a whole bunch of expensive stuff, thinks the seller has a whole bunch of money? What might they think about their offer price? I don't have to offer as much because look at all their stuff. They don't need more stuff. So I'm going to give them a low ball offer, right? So don't let your sellers look like they got lots of money, you know? And these are conversations we're having when we're listing, before we list the property. Depersonalize, take the stuff down. Can you get some stuff out? Get you a storage bin or what are those pods that sit in your driveway? Y'all know what I'm talking about? Those pack rats or things like that. You know, maybe we get something like that. I mean, guys, bottom line, the seller's moving anyway. So if we can get them to just live in the bare minimum for the next few months, then we don't have to worry about as much about their personal stuff getting gone, you know, and it's less that they have to do. So these are conversations we just need to have with the seller up front. Incorrect information about the property and other websites. It's always interesting to me. You know, Zillow and Realtor.com and all those sites are like a copy of a copy. And then you have third-party sites that are like a copy of a copy of a copy. We all know what the quality does to a piece of paper when you copy it multiple times, right? It's not as crisp, it's not as sharp. And same thing with listing a property in MLS. MLS has its fields, but those fields don't always translate to all of the other sites. The other sites accept it the best that they can, but it doesn't always translate 100% accurately. And what this is letting the seller know is, I mean, we can share all that with them or not, but bottom line, I have no control over what Zillow does. I have no control over AlanTate.com. The only thing I can control is what I put in MLS. How MLS feeds it, how other sites receive it may be a little bit different. So again, just having these conversations, making sure you put it in MLS right to begin with, that's what I can control. And then it's talking about the seller removing some personal. So it's talking about valuables, medications. Y'all don't have sellers keep their prescription meds in the bathroom counter or the kitchen counter or over the sink. Do you know where everybody keeps their meds? In the medicine cabinet, in the kitchen cabinet over the sink, right? Because that's where the water is and that's where we take our prescriptions. So have them do something else with them for showings, open houses, lock them up. True story. I showed a house once. My buyer and I walked into the primary bedroom, and I think I imagine the seller that morning took their pill, chucked the bottle on the bed, took a pill, chucked the bottle on the bed, took a pill. Because when we came in, there were like 5 or 6 prescription med bottles just tossed out on the bed. I really do hope that was an oversight, but I was like, okay, we're not going anywhere near this bed. We're gonna, stay as far away from this as we can. But just have the conversation with your sellers about how that could be bad, how that could go wrong. I don't know what they were. I didn't get that close to them. I didn't want to, So just having these conversations about their personal stuff. Service surveillance devices, seller's going to agree to disable any and all audio when the property is being shown. We're going to see more in a below section below. It's okay to have video, but there's some federal and state laws about audio. And again, we got a lot of technology in our houses right now, right? It starts with the Ring doorbell and it goes the whole way inside. So we need to have the conversation. We're going to see a little bit more about that in section 16. And then we talk about our money, fees and costs for the services. All caps, seller understands that the amount, format, or rate of real estate compensation is not fixed by law, but is set by each broker or firm individually and is fully negotiable. And then we're going to spell out the firm's fees. Seller agrees to pay the firm as follows for the services. Your firm may allow you to collect a non-refundable retainer fee from the seller. If so, we're going to list that here. That's going to be credited towards the firm's total compensation. Everybody hear me. Can you charge a broker a retainer fee? You, the individual, charge a retainer fee? No, that's up to your firm's policy. Your firm has to have that policy in place. Maybe our fee is a percentage of the sales price. Maybe we're going to charge a flat fee, or maybe there's other fees. Maybe, for example, you know your market because you're the expert of your market. And there's a lot of builders out there right now offering a buyer's agent bonus. So if your buyer's interested in new construction and you feel that there might be a bonus with it, then that's something that we can put in other. So we first discussed how the firm was going to get paid, and then we're going to discuss how we're going to cooperate with others. Seller has no duty to offer compensation to an agent working with a buyer. Firm has provided seller with the firm's best advice on the advantages and disadvantages of offering or not offering cooperative compensation. Seller does or does not agree to offer cooperative compensation. If they do, then we're going to check one of the following. It's either going to be a percentage of the sales price, or it's going to be per the attached firm's policy. So maybe they have their policy already spelled out, and we can just attach it almost like an exhibit to our agency agreement. But if the seller is going to pay whomever brings the buyer, if the seller is going to pay a buyer's agent's firm, then we have to discuss that here. Again, either a percentage or a flat fee. We got a form, by the way, I'm just paraphrasing a little bit. We got a form if the seller does agree or the listing firm does agree to pay a buyer's agent. I got a form for that, for everybody to sign, agreeing to that compensation to go from the listing side to the selling side. And then the next section down here, D, is total cost. So pretty much what we're doing, I'm going to come back up for a second. In B, we figured out what the listing firm was going to charge. In C, we figured out what we were going to pay the buyer's firm, if anything. So then in D, we're going to do a total. What's the total cost for commission? The firm's fee plus the cooperating commission. Similar to our buyer's agency agreement, we discuss when our fee is earned, and then we discuss when it's due and payable. Firm is going to earn their fee when they procure that ready, willing, and able buyer. Once I find the seller, that ready, willing, and able buyer, I have earned my fee. Let me ask you guys something. Say you're the listing agent, you get a new listing, goes on the market, and you get an offer, and it's everything that the seller ever wanted. It's their list price or more, it's cash, no inspections, they want to close in 2 weeks. Nobody could ask for a better offer. Does your seller have to accept that offer? And you guys are shaking your head no, and I agree. But let me ask you this. You presented them that offer. Didn't you procure them a ready, willing, and able buyer? Didn't you deliver them a ready, willing, and able buyer? Didn't you earn your fee? That's my job, is to procure them that ready, willing, and able buyer. What they choose to do with it. And guys, if they say, no, I'm not accepting this, then we got to go back to the drawing board, because I don't know what else they're going to want. I don't know what else they want. They're not going to get a better offer. Is everybody with me? But remember, once I've connected them, they don't have to accept. Once I've connected them, I've earned my commission. And if the seller rejects that offer, the firm may warrant that they've earned their fee, and they may go after the seller. But remember, it's the firm going after the seller. There's also a protection period. Now, we saw this in the buyer's agency agreement, but I'll be honest, I think it comes up more often in the listing agreement. And what the protection period says is that within X amount of days after this listing agreement expiring, remember, it's got a definite end date. So this listing agreement expires within X amount of days. If a buyer brings an offer, we might still be entitled to a commission. If I'm on the market today and we expired 11:59 p.m. tonight, and the buyer brings an offer to the seller tomorrow after it's expired, there's a really good chance that the buyer learned about this listing, that the buyer was first introduced to this property for sale. Isn't that through my marketing? I mean, I had the listing up until last night. So if a buyer brings an offer within X amount of days, I may be entitled to a commission. There's 2 caveats. One, this isn't just any old buyer. I got to be specific. If I know we're expiring today and I know the Joneses are interested, I got to tell the sellers, if the Joneses bring an offer, I need you to contact me. So it's not just any old buyer, it's buyers that you know have an interest. The expiration date is not advertised, you guys. Only the listing firm sees the expiration date. So if a buyer sees it today, they don't know it's expiring tonight. Does that make sense? It might be they just started their home search this weekend. The second caveat to the protection period, we expire today. The seller lists with a new firm tomorrow. Who is the current exclusive right to sell listing agreement with? The new firm. So if the Joneses come forward after they list tomorrow, then the new firm will get the commission, because that's who has the current exclusive right to sell. But without those 2 caveats, we still could be due a commission. This protection period is protecting us. It's protecting the firm's commission. So we discuss when that fee is earned, and then we discuss when it's due and payable. The firm's fee earned will be due and payable to the firm at closing. Seller's default, seller's unreasonable cancellation. That's when the firm may choose, if it doesn't close, if the seller was in breach, if the seller wanted to terminate the contract, if they're not accepting offers, our fee is due and payable, and that's when the firm may decide to go after the seller, may decide. Yes, Brittany, good morning.
Good morning. So at closing, that means like once it's recorded, right?
Done
Once
deal.
it's on record, I'm paid.
Yep. Yep. So isn't that interesting? I've earned it when I put you under contract. I've earned it when I've given you that ready, willing, and able buyer. But I'm typically not paid until it's a done deal, which kind of says to me our agency duties continue after presentation of the offer. We're going to get them through to closing. Yep. Let's see. Home warranty, maybe the seller does or does not agree to a home warranty. Pre-marketing home inspection. Some sellers may want to have a pre-marketing home inspection. Again, just think of this as a jump point of conversation, a jumping point of conversations, the benefits of having a pre-marketing home inspection. Earnest money deposit and due diligence fee. We're going to talk about these when we get to our contract in Unit 8, so I'm not going to say much about this now. But we are going to have the conversation with the seller that when the contract does come in, there's a good chance it'll come with earnest money deposit, it'll come with due diligence fee. And we're just kind of spelling out to the seller what that'll look like when an offer comes in. Again, much more on earnest money and due diligence when we get to Unit 8. And then we talk to the seller about dual agency. Make a note. I'm in our listing agreement on page 4. I think you guys should read this section about dual agency. It's dual agency as it's explained to the seller. What does this mean for the seller for us to be in a dual agency? So I think you guys should. We also saw this in our buyer's agency agreement. Firm may not act as a dual agent, or the firm may act as a dual agent. So either may not act as a dual agent, or they may act as a dual agent. We got to have the seller initial one or the other. Either they agree to do dual agency or they want to remain exclusive. They do not want to do dual agency. If the firm may act as a dual agent, then we're instructed to initial only one line below. So the seller does not authorize the same agent to represent both seller and buyer. Seller does authorize the same agent, or the firm practices designated dual agency, and that's what we're going to go for. Remember, if they say no to dual, designate is not an option. And our listing agreement reinforces that. It helps us make sure that we're good with that. And also remember, you guys, specifically for your exams, designated dual agent is not automatic. It has to be added. It has to be included for the firm's policy. And on your exams, you're not going to automatically add designated dual agency. You need to see it to know that we're practicing it. Head bobs, everybody heard me. Okay. Let's see. Disclosures and representatives. I love this new section. Our former agency or listing agreement was like 13 pages. And why it was so much more was because of this section right here. So they took number 12, they consolidated it, and they gave us a very, very handy dandy checklist. Seller is or is not working with a relocation company. Seller has or has not received sample copies of documents. Seller has or has not owned the property for at least 1 year. And it goes down to like W. I was going to say V, but it goes down. I mean, it's the whole, yeah. This is your jumping off point for conversations. This is the thing that you can look at the seller and say, they do or do not have a mobile home on the property. The property is or is not subject to restrictive covenants. It is or is not in a flood hazard. I'm not going to go through all of this, but this is so convenient. And we can actually sit there with the sellers and treat this like a checklist, because you know what? It is. And this is also going to help us identify and learn various things about the property as we go through this with the sellers. Very excited about this new section. Love it. Y'all ever hear people talk about forms like that? But this was definitely an improvement. Many props to the forms committee for this change, giving us that ability to have these conversations with the sellers. Remember, our agency agreements are a two-way street. So the firm has duties to the seller, and guess what? The seller has duties to the firm. So we spill those out. Seller agrees to fully cooperate with the firm, provide reasonable access to the property. The seller's got to let people in the front door. They got to let prospective buyers in for showings. Once that buyer goes under contract, they got to let their home inspector in, their appraiser in, whomever it is they want to do their inspections and investigations. So the seller has to provide, and note that word reasonable. We're still going to be accommodating. We're still going to work with the seller and their schedule. The seller is going to provide firm information and documentation upon request. Seller is going to allow firm to provide documents to other parties as necessary to facilitate this transaction. Seller has a duty to deliver a general warranty deed at closing and then comply with the purchase contract. Surveillance, photography, and video. This first section is pretty much telling the seller that the pictures that I take of your home, those are my pictures. So if the seller relists with another firm, that firm needs to come in and take their own pictures. They can't use mine. That's called copywriting. This is even though they're pictures of your home, they're still my pictures. If I do a Matterport tour, if I do a video, whatever I do to market or advertise, it's mine. This is once again cautioning the seller about leaving personal or valuable or sensitive confidential information out. Let's not leave our bank account statement laying open on the desk during a showing, right? Right? You'd think you wouldn't have to tell these things to people, but guys, let's have these conversations. I'd rather say it, have them look at me and go, okay, Julie, than not. The other thing this is telling the sellers is that the buyers, as we saw in our buyer's agency agreement, the buyer may take pictures of the space, but they are prohibited from honing in on the stuff. I'm focusing on the seller stuff. So it's kind of twofold. If the seller doesn't leave out temptation, then the buyers won't be tempted. Makes sense, right? Other professional advice, we saw this in the buyer's agency agreement. I think it's more applicable in the buyer's agency agreement because there's a good chance at some point in the transaction, your buyer's going to look at you and say, who do you recommend for a home inspection? That's me offering other professional advice. The seller, this may come up, especially as we're getting it ready to get on the market. So you might be that you suggest that the seller cleans up the front yard, trims the bushes, right? That curb appeal makes the front yard look nice. And the seller may look at you and say, gosh, I don't have time. Can you recommend any landscapers? In which case I'm offering other professional advice. I'm just letting the seller know that I'm not responsible for these people that I recommend. I'm recommending them on a good source, on good faith. I'm not going to go to Google and find them a landscaper. I'm going to go to my resources. If I don't have a landscaper in this area, I'm going to go to an agent that does. Say, who do you recommend? We're going to give them reliable advice, professional services. Let's see, another good one. Confidentiality. The firm will not disclose the price or other terms of an offer by a buyer or a competing party without the express consent of that buyer. So if you're a listing agent and you're in a multiple offer situation and you have multiple offers in your hand, by the way, we're going to talk about multiple offers when we get to Unit 8, but you have multiple offers in your hand. Listing agents, you can expect a buyer's agent to call you and ask you, what's the highest price offer you have in your hand right now? And before you answer that question, I really need you to think, because there's a commission rule that says I cannot disclose the terms of the offer without that person's consent. So if somebody calls you and asks, what's the highest priced offer you have in your hand right now? Your knee-jerk reaction might be just to blurt out a number, but you've just violated commission rule. So your answer is, I cannot disclose that. Tell your buyer to bring their best, and we'll consider all offers at this time. There's no rule preventing them from calling and asking. The rule addresses how you respond. Everybody good with that? You got to stop and think, y'all. That's hard to do sometimes, isn't it? Trust me, I know, but you got to stop and think. Keep in mind too, this goes on to say that the seller doesn't have to treat the buyer's offer as confidential because the seller is not held to license law and commission rule. The real estate commission only regulates licensees. This is another good reason why I don't want the seller to talking to anybody but me. I'm the only one I want them talking to because the seller's not bound to the same law and rule that the broker is. The seller can, that doesn't mean that they should. Wire fraud, again, we saw in the buyer's agency agreement, just letting your buyer know that, or excuse me, letting your seller know if they want their proceeds from closing wire transferred to them, they need to go old school. They need to call the closing attorney on a number that they get on their own, or you give it to them. But they need to pick up the phone and call the closing attorney to give them their wire transfer instructions. Don't follow instructions on an email. Don't call a phone number in an email because then you got them calling the hackers. So when it comes to wire fraud, email, no, email is bad when it comes to wire fraud. I mean, y'all think about our Gmail emails. My Gmail is about as secure as my closet door. Right? Yahoo, Outlook, whatever you're using, there's no security. Yeah, you can put on a two-step authentication, but they figured out around that as well. So just be very, very careful with your email, the information you have in the email. Just be very careful with the information that you're sending on. And make sure you have this conversation with both parties. Do not rely on an email about wire fraud instructions. Additional terms, this just kind of gives us the ability to plug in anything else that the firm and the seller agree to that's not already addressed here. Remember, the firm is a party to the contract. So the firm can put in verbiage. The firm can add verbiage. What you, the individual broker, can do is going to be up to your firm's policy. Probably one of the most common things that I've seen in additional terms. Seller and listing agent agree to a listing price. And maybe that listing price is more than what the broker thinks we can sell the home for, but the seller really wants to sell it for this. So we work out a deal. All right, I'm going to list it for this for 2 weeks. And if we don't have an offer, then on 2 weeks, we're dropping the price to what I think we should. Deal? We'll try it your way first and see how it goes. But I'm giving you 2 weeks. And if it doesn't work, we're changing the price. If the parties agree to something like that, that would be an example of something we put in the additional terms. Then our boilerplate clause, merger, termination, modification, assignment, enforcement, attorney's fees, and governing law. There's a whole lot going on in that paragraph, but it's all boilerplate, standard language that we see in a listing agreement. Another one of our musts is our non-discrimination clause. So we let the seller know the firm is going to conduct all brokerage activities in regard to this agreement without respect to the protected classes. So we're going to let the seller know that the firm doesn't engage in any activities that's considered discriminatory. We're going to get into fair housing today. So we'll identify and discuss the protected classes and what that means for us. And then the bottom of page 7, we get everybody to sign it. I got a place for 2 individual sellers. I also have a place for an entity seller. So maybe you're selling something owned by a corporation or an LLC, in which case one person is authorized to sign on behalf of the entity. If you have more than 2 individual sellers or more than 1 entity seller, I got a form for that. And it's our additional signatures addendum. So remember, we want everybody that has to show up on closing day to sign this deed to convey this property. They all need to be on board on day one, and their spouses. So make sure you have everybody on board on day one to list this property. Again, if you get a spouse that says, no, I'm not signing the listing agreement, I got a lot of questions. What's going to guarantee they're going to show up on closing day? And if everybody doesn't sign on closing day, the seller can't convey, the seller's in breach, and game over. So I'd rather have these hard conversations up front. And then we got a place for the firm, name and license number, signed by the individual agent, another one of our musts, because you're the one signing it. You need to include your license number. Go ahead and memorize that when you get it. It's a 6-digit number. And then the firm's contact information. And that is our 7-page exclusive right to sell listing agreement. It used to be 13. They took out some paperwork for us. Questions? All right, let's go ahead and take our first break. When we come back, we're going to wrap up working with sellers. welcome back. So I'm going to take attendance. And by the way, one more thing about this whole wire fraud thing. If you guys, just be careful when you're working on public Wi-Fi's. So maybe you want to go to Starbucks this afternoon and get some work done and work on a public Wi-Fi. Y'all know who can access the public Wi-Fi's? The public. So when you jump on a public Wi-Fi, you run risks there, especially when you're dealing with your own sensitive confidential information or your client. So best bet, if you want to work out in public, hop on your mobile hotspot on your phone. That'll give you that little bit of security and they can't access that. So there's kind of your free tip for today. That's not just with your client's information, but that's with yours as well. Okay, so we're back. And we just looked at our listing agreement. And my stuff is a little jumpy today. Am I okay on y'all's end? Yeah, okay. How we can help our sellers figure out, if I sell your house for X amount, what are you going to net? Or more accurately, if they want to net X amount, what do I need to sell their house for? So in the real world, you know, for pre-licensing world, we're sitting down with pen, paper, and calculator. But in the real world, we have something called a seller net sheet. And it allows me to put in all the seller's expenses, all their closing costs, and the sales price. And the interactive form of this form is really cool because you put the information and it be boop boop, it calculates for you. And they actually give us a nice, you got 3 columns where you can do a nice side-by-side comparison. If I sell your house for this much, this is how much you're going to get. If I sell your house for this, if I sell your house for this. So we can actually look kind of down to the nitty gritty. There's something called a seller net worksheet you have to look forward to when you get in the real world. Even with our listing agreements, even with the sellers, we still have to determine if the seller is going to make money or lose money. Remember, if they owe more than what I can sell their home for, they owe more than what I can sell their home for, then that seller is underwater. And then we have to ask, we have to decide, can you afford to sell your home? Can you afford to bring money to closing? And if not, we might be in a potential short sale situation. They might be heading towards foreclosure. What I just did was identify the red flag, and then we need to proceed how to go from there. But we got to have these hard conversations up front. So let me ask you guys, the seller, you've done the net sheet, is determined that the seller is going to lose money. It determines that they owe money at closing. And I know we haven't talked about material facts yet, but what do y'all think? Is this material? Is this something that we should share with the buyer? And I got head shaking both ways. And you know what our favorite answer is? It depends. If the seller has missed a payment or 2 payments, it's not a material fact. I don't need the world to know that they missed a payment. However, if they are in foreclosure, if they are in a short sale, now it's a material fact. Now we have to disclose that. So there's a difference in missing a payment versus defaulting on your loan. Miss a payment, no big deal. That's nobody else's business. They've defaulted. The bank's in the process of taking the property or a few steps away. Does that make sense? And again, this is just the hard conversation that we need to have up front. Make sure the seller understands. Just based on what you've told me with your approximate balances, with this information, I feel like you might lose money in this transaction. Let's talk about this. I'd rather have these conversations up front than finding out at the closing table they don't have the money. If they don't have the money, they can't convey. Thus, they are in breach and game over. So let's have these hard conversations. Y'all, you just met this person and you're already getting all up in their finances and telling them to put their prescription meds up, right? I mean, we're getting awfully personal, awfully fast. And that's kind of the way it is. That's kind of the way it is. So that officially, we were so close to being done with our SellerNet, but that officially wraps up that conversation. So the only two maths we have in this unit we've already seen. We did our commission math and we did our SellerNet math. Questions about the listing agreement? Questions about working with the seller? Questions about anything we've covered so far? All right, so in this next section, we're going to talk about how they end. All good things must come to an end, yes, and that does include our agency agreement. So we're going to talk about how our agency agreement, specifically our listing agreement, terminates. Awfully similar, same thing with the buyer's agency agreement. Hopefully, your number one reason for your agency agreements to terminate is because they all close. Full performance will terminate an agency agreement. Once you have completely done the job that you've been hired to do, my services are done. So if we're in a listing agreement together that expires the end of May, I'm making dates up. It expires the end of May, but we close on your house the 1st of April. We're done the 1st of April. I have fully performed what you hired me to do. I don't owe you any other duties through May. So full performance, let's all shoot for that. Every day when we get up, let's shoot for that. How's that sound? Everybody agree with me? Let's do that. May not always happen that way. So there's other reasons that might terminate our agency agreements. We know we have to have a definite end date. And when it's over, it's over. Could we agree to extend it? Sure. Why not? Right? Do we have to extend it? No. The parties have to agree to extend it. And if we do extend it, we need a new definite end date. So when they're over, they're over. My agency duties are no more. Another thing that could terminate our agency agreements is mutual agreement. The firm and the client agree to get into the agency agreement together. So the firm and the client can agree to get out. Did you hear my key word there? Did I say the broker can agree to get out? I said the firm. Can you fire your seller? No, because remember, despite what you say, it's not your seller. It's the firm seller. So if you're having a problem with the seller, if you're having a problem with the buyer, just go to the BIC. The BIC is going to try to want to salvage the deal. But at the end of the day, if the BIC can't or won't, then the BIC and the seller may agree to mutually terminate. They may mutually agreement to terminate the agency agreement. Breach. We saw firm's duties to the seller. We saw seller's duties to the firm. And we also saw this in our buyer's agency agreement. Both parties have duties and responsibilities to each other. And if they don't do what they promised to do, they're in breach. And breach may terminate the contract. You know, one of the things, responsibilities we saw the seller is to make the property available for showings at reasonable periods of time. Well, if the seller, as we discussed, if the seller never approves a showing, they never let a buyer in the front door, haven't they breached their duties? They didn't allow me to show the property during reasonable times. They have breached, and that may terminate the contract. Something else that may terminate specific to the listing agreement is operation of law. If the judge takes the property for any reason, it's no longer the seller's to sell. If the seller loses the property in foreclosure, eminent domain, adverse possession, if the judge takes the property for any reason, it is no longer the seller's to sell. Thus, that would invalidate our listing agreement. Also specific to listing agreements is destruction of the property. If the house burns down, the house you have listed for sale burns down, I no longer have that product to sell. And that would terminate the agency agreement. Now, it might be after the insurance cloud settles, it might be that we're asked to sell the land, in which case we would use a different agreement just to sell the land. Does that make sense? So the house burns down. Where it stands right now, I don't have a listing agreement because I don't have the product that I promised to sell. Another thing that'll terminate our agency agreements, if the client passes away, seller or buyer, the client passes away, that will terminate our agency agreement. What if the individual agent passes away? The individual listing agent. Y'all are shaking your head no? Show must go on, right? Because the relationship is with the firm. Not unless you're a sole practitioner. If the agent's a sole practitioner, they are the firm. And if that sole practitioner passes away, then that terminates. But if the agent's with a firm, that's who the relationship is with. So in order to terminate an agency agreement for death, it's the firm that has to die. And what we mean by the firm dying is they shut their doors. So let's say our agency agreement expires. Our agency agreement is up tonight at 11:59 p.m., which means at the stroke of midnight on March 12th, we don't owe each other duties anymore. And for the most part, I'm done with old car. When our agency agreement expires, I no longer owe you old car. If I have any outstanding promises or obligations, I still have a duty to fulfill those. If I told you I was going to do something, even though it's expired, we're always going to honor our promises and obligations. But one of the more common things that comes up when our agency agreement expires and we no longer owe these clients old car, one of the common things that comes up is this also include confidentiality? When our agency agreement is up, I no longer owe you old car, but that doesn't give me a golden ticket to run around blabbing your confidential information. So the idea of confidentiality is going to remain intact. You don't have a right to run around sharing this seller or buyer's confidential information once the agency agreement expires. Unless, let's run through a scenario. You're the listing agent. Your agency agreement is up tonight at 11:59 p.m. Next week, the seller lists with a different firm. I'm still owing them confidentiality right now, right? Our agency, our old car was up after it expired last week, a week ago. But now they've listed with a new firm. And guess what? You now have a buyer client that's interested in that firm's listing. Who has old car today? Yeah. Who has old car today? Your buyer, because they are the ones in a current agency agreement. So they want to go see this home that you had listed last week. Who gets that confidentiality now? Don't I owe it to my buyer client to share with them what I know about the seller customer? Now, I get a lot of questions about this. And here's the deal, you guys, as we've said, the seller doesn't have to accept any offer. So let's say that your buyer client wants to make an offer. It comes across the seller's desk with my name on it as the buyer's agent. And they said, God, there's that Julie Campbell chick again. I thought we were done with her. And now here she is bringing us an offer. Does the seller have to accept that offer? If they're so worried about what I know, if they're so worried about working with me, do they have to accept that offer? No. But I still do it. My duties are whomever has the current agency agreement. Honestly, in that case, I'd probably call a buddy from the firm and say, will you present this offer for me? Because if my buyers want this home and my name attached to it could be any reason for them not to accept it, I want to do what's best for my buyers. So I may bring in some help. Does that make sense? But we have to remember, you always have to remember that who gets old car today is who is in the agency agreement with you today. They may not have gotten old car yesterday and they may not get it tomorrow, but it's whoever your current agency agreement is with. Is everybody good with that? Again, always look up towards the firm. Who are they in a relationship with today? Questions on the confidentiality thing when we terminate or expire? As we saw in our listing agreement, even after it expires, you could still be entitled to a commission. And that's something called the protection period. This is one of these fun things. Also could be referred to as the extender clause, also known as the overrider clause, also known as the tail clause. I don't know why. But what I know is that protection period can be called one of four things. And again, what that protection period is protecting is you. It's protecting your commission. If a buyer brings an offer after we expire, X amount of days after we expire, I may be entitled to a commission. And then as we also saw, if the seller doesn't perform as promised, there's that difference in when we've earned our commission versus actually when we get paid. So maybe the seller commits fraud, they change their mind or refuse to sell, they're not going to accept that dream offer. They have a title, they have a incurable title on corrected defects that could cause the seller to be in breach. Insist on terms not in the listing agreement. They change their mind and decide they want more money or something that's not spelled out in our listing agreement. Mutual agreement, refuses to accept an offer from a protected class, or no closing is required. All of these are reasons if the seller chooses not to sell because of these reasons. These are all examples of times that the firm still might be entitled to that commission. Questions? So in the next section, we're going to talk about some seller disclosures. And the seller disclosures fall under the Residential Property Disclosure Act. So we're going to talk about this Residential Property Disclosure Act. We're going to talk about the seller disclosures, their obligations to disclose and not to disclose. and then talk about how that is addressed in the two forms that we have. We're also going to talk about some prohibited acts. We're going to talk about omission and misrepresentation, and whether or not you omit or misrepresent intentionally or on accident, and what could happen. And that conversation gets us into our deep dive of material facts. We've danced all around it, but we are finally here. We're going to talk about our material facts and exactly what that means. And we're also going to talk about things that are not material in North Carolina and how we can address those as well. So let's start with our seller disclosures. And with the seller disclosures, again, under the Residential Property Disclosure Act, I have a couple forms. And one of those forms we have is something called the Residential Property and Owners Association Disclosure Statement. Goodness, that's a mouthful. Are you guys good if I call it RPODS going forward? Because if I try to say Residential Property and Owners Association Disclosure Statement every single time, I will trip all over it. So RPODS it is. We know what I speak of, right? Go ahead and jot it down so you have it in front of you. So the RPODS is a seller disclosure. So hang on, before we get into this, let's back up. North Carolina is a caveat emptor state. Who can remind me what caveat emptor means?
Buyer beware.
Buyer beware. So in North Carolina, the onus to learn about the property, the responsibility to learn about the property is solely on the buyer. The seller doesn't have to disclose much. There's only one thing that I've ever come up with that the seller has to disclose, and we're actually going to talk about that later today as well. So caveat emptor says that the seller doesn't have to disclose much. The responsibility to learn about the property is on the buyer. So with that being said, we have seller disclosures. Go ahead and write something down for me. Seller disclosures are mandatory forms with optional disclosure. Mandatory forms, which means the seller must provide them. Under the Residential Property Disclosure Act, the seller must provide disclosure. But caveat emptor says they don't have to disclose much. A mandatory form with optional disclosure. The seller has a choice to make. Do they want to disclose what they know? Do they want to disclose the defects, the issues of the property, or do they want to keep their mouth shut? Seller disclosures. Remember, you guys, please always remember, only the seller can hide behind caveat emptor. Only the seller can choose if they want to disclose or not. The licensee always has a duty to disclose material facts, regardless of how the seller completes their seller disclosures. So it's a required form of most residential properties. Note that word residential. That does include private sales, so we're referring to for sale by owners. For sale by owners, they're not working with an agent, but they still have to provide the form because this isn't a broker form. This is a seller disclosure, a seller form. Now, there's a few exceptions. Not all residential properties have to use the RPODS. New construction is exempt from the RPODS, or if I may word that differently, never before lived in dwelling. If nobody's ever lived there, can they tell you fully about the conditions of the home? I mean, they have an idea because they built it, but they never lived there. They never stayed the night. So new construction is exempt from the RPODS. Foreclosures or bank-owned properties are going to be exempt from the RPODS. Option to purchase, a lease with an option to purchase is exempt. By the way, we're going to talk about leases and we're going to talk about option to purchases. For right now, let's just understand they're going to be exempt from the RPODs. Any kind of transfer between co-owners, spouses, heirs. So this is the short list of who's exempt from providing the RPODs. And again, please make a note, the for sale by owner is not exempt unless they're new construction, foreclosure, lease with option to purchase, etc. So you guys have been hearing me, and I've been calling these seller disclosures. Who is responsible for completing these forms? The seller. I'm not completing these forms for them. This is a seller disclosure, which means the seller is responsible for completing it. I can assist them. I can help them. I can provide them the form. I often do. Here's the form. This is how it works. This is what you need to know. I cannot do it for them, and I cannot tell them how to do it. I'm going to give them their options and let them decide how they want to complete this form. And we're going to look at this, by the way, in just a minute. We're going to see the RPODs. So with the RPODs, the seller has three choices. We're going to go through and ask them a series of questions about the property, things about electrical and plumbing and structural, things for the seller to identify any potential problems with the property. And when we look at the form, we're going to see that the seller has three choices. They can say, yes, there's an issue. No, there is not. Or I'm going to exercise my rights under caveat emptor and say, no representation. The seller has every right in the world to say no representation. Now, you guys, especially brand new, you guys like to look at an RPOS that says no representation and just assume it's a shady seller that's trying to hide something. I don't know. Maybe they are, maybe they're not. What if it's a case where the tenant has been living there for the last 15 years? What can the seller truly answer about that property? What if, you know, heaven forbid something happened to my parents? I haven't lived in their home in like 30 years now. What can I truly answer about their, everybody with me? Like, I think they got a new roof a couple years ago, but what can I truly attest to? So it could very well be that the situation, the seller's best bet is to say no representation. If they choose to disclose issues, then they're selecting yes. If they choose to disclose there are no issues, they're selecting no. Or for whatever reason, they're selecting no representation. Under caveat emptor, the seller can select no representation even if they know there's an issue. Again, they're exercising their rights under caveat emptor. But regardless of how the seller completes this form, brokers, we always have a duty to disclose material facts. So if the seller says no rep on the whole thing, but we know of an issue, we've got to disclose. And yes, we are having these conversations with our sellers before we start running around blabbing all this information. We're letting them know my duty to disclose. The seller's duty with the RPOs is to deliver it to the buyer no later than the time of contract formation. If the buyer goes under contract and they still don't have the RPOs, the buyer has 3 calendar days to rescind their contract. So what's the big deal? The buyer could walk away. Now, I'll be honest with you guys, the majority of the time, like 98% of the time, most of the time, when we look in MLS, when you log into MLS, you can see attachments to a listing. The public doesn't see the attachments, but you'll have access to that through your MLS. And 98% of the time, part of the attachments are these seller disclosures. So the majority of the time, before you even show the property, you're going to see the RPOs, you're going to see these seller disclosures, which is really helpful when the seller does disclose there's an issue. Because you can call your buyer and say, hey, I see here the seller's disclosed major structural issues. Do you still want to go see it tomorrow? If the seller said no or no representation, then obviously we need to go check it out. But most of the time, you guys, I don't want you worrying about getting these forms, because most of the times they're going to be available. And the few times, the few rare exceptions that they're not, you just need to reach out to the listing agent. Hey, I'm seeing your property. I want to see an RPOs. Or hey, we're bringing you an offer. I want to see the RPOs. But most of the time, it's available to you. With that being said, if the seller doesn't provide the form, a contract is formed, we are under contract, and the buyer has 3 days to rescind their contract, which means they can take it back. If they put down any deposits or fees, they're going to get their money back. If you rescind a contract, it just poof, goes away, and all parties proceed with their lives as if this never happened. Brokers, our responsibility when it comes to the RPOs is to facilitate delivery from the seller to the buyer. I'm going to get it, as the listing agent, I'm going to get my seller to complete it. As the buyer's agent, I'm going to get it in their hands. So I'm going to play delivery man, and the vehicle I use to get it to the buyer does not matter. It does not matter, just as long as I get it from the seller to the buyer. Buyer's agents, if your buyer's going after a for sale by owner, you probably need to hand the blank copy to the FSBO, tell them their duties, their obligations to complete this form, and then assist in delivery to your buyer. It's a seller form for the sellers to complete. It's a mandatory form, which means the seller must provide it. Again, if they don't, could give the buyer an out. Mandatory form, optional disclosure. And we're going to look at the RPOs in just a second. But before we do that, let's talk about the other seller disclosure that the Act gives us, Residential Property Disclosure Act. And the other disclosure that the Act gives us is the Mineral and Oil and Gas Disclosure Statement. Again, everybody good if I call it the MOG. The Mineral and Oil and Gas. Teaching y'all speak broker already. RPOs, MOG, your fellow brokers know what you're talking about. That's one thing I learned about real estate. If we can make an acronym out of it, by golly, we're going to. So the MOG, the seller has to disclose their status of their subsurface rights. Remember, we talked about your subsurface rights, and those subsurface rights can be severed. So whether or not the seller has severed or intends to sever the subsurface rights will be spelled out in the MOG, and we will also look at this as well. The MOG is exempt from vacant land. When you're selling dirt, the MOG is not required. I know, right? I know. Makes no sense. Because what are we disclosing? We're disclosing what's underneath the dirt. It doesn't matter if there's a structure on it or not. Y'all want to know my belief? This is what I think. The MOG falls under the Residential Property Disclosure Act. The Residential Property Disclosure Act only covers properties with residential properties. I think they found a loophole. That's what I think. But because it's vacant land, because there's no residential property, it's not covered under the Act. And I will say, and where I'm recording, that's about the dumbest dang law that we have. Because shouldn't it be disclosed if you're buying dirt? All right, I'm done. soapbox of the day. Well, this time. I'm sure I'll find another one to. And again, you guys, these are seller disclosures, which means I'm not going to complete for the sellers. And look, sometimes the sellers are going to make this so frustrating. They're going to kick back and argue. And sometimes it's going to be so easy to say, oh my God, just give me the pen. But I can't. I cannot complete this form and I cannot tell them how to do it. I'm just offering them their choices. I'm letting them know their options. And the big responsibility for the broker is that I'm going to play delivery man. I'm going to get it from the seller to the buyer. And again, the vehicle doesn't matter. The MOG is required for new construction. The exceptions are different from the MOG and the RPOs. So what we're going to do now is we're going to go out and we're going to look at both forms, the RPOs and the MOG. These are in Learn Test Pass. They're going to be under the Unit 3 material. If you want to review these, you have these available under the Unit 3 material. So the RPOs, it starts with, I love it when forms start with a law. This is a state law, North Carolina General Statute. If you actually want to read that law or go over it with your sellers, you can click on that link and it'll take you straight to it. Of course, you can also Google it. So this isn't the Real Estate Commission. This is state law. This is North Carolina state law. Form provided by the commission, but is state law. So an owner is required to provide a response to every question by selecting yes, no, or no representation, or not applicable. If an owner is not required to disclose any of the material facts, even if they have knowledge. However, failure to disclose latent defects may result in civil liability. A latent defect is one that is hidden. Maybe the seller knows about it, but there's no way anybody else can, for example. So a latent defect is a hidden defect, and the seller is encouraged to disclose latent defects, because if it's discovered after closing, then they may be held liable. In other words, the buyer could take them to court. How far are they going to get? I don't know. But what I do know is the seller should be encouraged to disclose latent or hidden defects. And then it goes on to discuss the options. If you select yes or no, if you select no, you're saying you have no actual knowledge of the topic. If you select no and you know, you could be held liable. So if the seller's really tempted to say no, their best bet may be to say no representation. But remember, it doesn't matter how they complete it, because once I learn of a material fact, I always have that duty to disclose. So in some cases, no representation might be the best bet for the seller. Let's see. Talking about the seller's duties, depending on who you're talking to, the buyers. Buyers are encouraged to review the disclosure statement. And the buyers are also encouraged, regardless of how this is complete, the buyers are always encouraged to get their own home inspection. So even if the seller says, yes, everything in this house is broke, the buyer's still encouraged to have their own home inspection, because the home inspector is going to get more specific. And then we have a note to the brokers reminding us in all bold, there it is, that the broker is not allowed to complete, not permitted to complete this disclosure form on behalf of their seller clients. And then we get into different sections. So section A is asking the seller questions about the structure, floors, walls, ceiling, window, and roof. And you can see on the right there, their options are, for the most part, yes, no, or no representation. So the seller's literally going to go through this form and check yes, no, or NR, no representation, for each section here. So there's section A, and again, I'll let you guys look over this if you want. Section B is getting into the HVAC and electrical. Are there any known issues with the HVAC or the electrical? C is about the plumbing and water supply, sewer and septic. D is about fixtures and appliances. Any fixtures that are going to stay, appliances that are going to stay, and are they in good working order? Land and zoning. Are there any potential zoning changes? Is there anything with the land, with a private road, for example? E is environmental issues and flooding. Of course, miscellaneous. And then if the property's in an owner's association, if it's in an HOA, then the seller has the opportunity to disclose information about the HOA. If it's not, then we don't need to worry about this last section. So the RPOs, the seller's going to go through, is encouraged to go through. Again, all I can do is give them their options. Your options are to say yes, no, or no representation and talk to them about what each option means. And again, being familiar with the form helps put words in my mouth. So you don't have to create the wheel. We can use this page to have these discussions with the seller about what their options are. Has this been updated recently? Yes. We just got a new one. Let's see, that's May of 24, so it's not a year old yet. You're thinking of the previous one that was 4 pages and it was like font 6. Even when my eyes were good, I still needed magnifying glass, right?
Yeah, it was just like I sold back in 2022, and I remember
Yeah.
this form, and it was called an RPD. It didn't have all this other stuff, I don't think.
Yep.
But there was just easier ways to check. I felt like this looks a little different.
I like this a lot better because I mean they've gone from 4 pages to 6, but big part of that is because they've increased the font. So now we can actually read it, you know. But I do like, and this is just me, you know, but I do like that it now kind of sections things out. It used to be everything was lumped together, but now we're going to talk specifically about structural, floors, wall, ceiling, window, roof. Then we're going to talk just about plumbing. So I do like that it kind of sections it out a little bit. But I'm a big fan of the font size that we can now all see. So, you know, and that's the one thing with the forms is we can always expect changes. But yeah, I do forms for my firm. I'm compliance and form, and that's me. And I remember the sales meeting when I rolled out the new RPOs, and I was like, it's 6 pages now, and there's a collective. Oh, I was like, hang on, you know, bear with me. There's a reason why it's 6 pages now. And they're like, oh, okay. So I feel like this was a good change, and I think it's easier for us to have these conversations with the sellers. But again, I'm just going to be aware. I'm going to be knowledgeable on what's on this first page so I can have these conversations. Thank you, Brittany. Other questions on the RPOs? The other seller disclosure then that we have is the MOG, or the Mineral and Oil and Gas Rights Mandatory Disclosure Statement. So again, it starts with instructions to property owners, throwing a North Carolina general statute at them, going over the Residential Property Disclosure Act. Again, it's just here for a reference, but I like it here for a reference. If we need more information, we have that. We can always throw it in Google. When mineral and oil and gas rights have been severed or are going to be severed, I think as we can imagine, this is a highly legal thing. So part of the disclosure is making sure that any attorneys are involved if necessary. I mean, I don't know much about the process myself, but I can only imagine the legalities in severing somebody's mineral rights from the land, right? Well out of our realm, well out of our lane. So if we are dealing with this, we have attorneys involved, and I mean, that's the good news. And then we have things for the seller to disclose. And I think the best way to see this form is to kind of take it and chop it in half. So 1, 2, and 3 is asking the seller about mineral rights. So mineral rights were severed from the property by the previous owner, in which case the seller has the right to say yes, no, or no representation. Seller has severed the mineral rights, or the seller intends to sever the mineral rights. So either they have or they plan on it before they close. And y'all check out their options. The seller can no longer say no representation. Can we agree that a buyer deserves to know what they're buying? And if the seller has severed those several subsurface rights, or they intend to, the buyer has the right to know this. So the seller's actions do not have the option for no representation. They can only say no representation from the previous owner. And then we go through that same little exercise talking about oil and gas rights. They were severed from the previous owner, yes, no, or no rep. The seller has severed oil and gas rights, or the seller intends to sever. So a little bit more restrictive for the seller. They don't have that no representation option. But it just kind of reinforces our whole thing when we say that a buyer deserves to know what they're buying. And then we go on to note to purchasers. Again, what happens if the buyer doesn't get this? And this is discussed here. If the buyer doesn't receive it, we go under contract. The buyer has 3 calendar days to rescind their contract. They could cancel or rescind their contract for lack of failure to receive this form. This is still only a 1-page form for now. But both parties sign it. The seller signs acknowledging that they've looked at this disclosure. All information is true and correct. The buyer is acknowledging that they've received it. ARPODES and the MOG. And this is a form especially that we need to make sure we talk to the sellers about. This isn't the most easily identifiable, easily relatable form. I had a listing once and I went over the form, and when I went to pick it up from my sellers, that's not right. That's not right. Let's sit down and talk about this form again, because obviously I didn't do a good job explaining it. So we had that conversation about why you can't have all yeses yet. I appreciate what they were doing. Let's be upfront and honest, you know, but you just, so that was on me. And sometimes we learn that. We just have to sit down and revisit, okay, let's try this again. And that's another way how we learn. So just making sure that they understand what it is they're filling out. Questions? I said, if y'all say yes to everything, we need attorneys now, right now. And they said, we don't want to call it. I said, okay, so let's revisit this. Questions on the ARPODES or the MOG? Got a little bit more to say about the Residential Property Disclosure Act. But before we do that, yes, ma'am, Chantel.
What if they didn't know about the MOG or the other disclosure before they moved there? How would they find that information out?
So then if they didn't get that, then that's kind of on the agents. But remember, the buyer's doing their inspections. If those subsurface rights have been severed, then they're going to be recorded. So the closing attorney would have found it before you bought. So as long as you have your home inspection, as long as you have a closing attorney, even if the seller doesn't provide it or isn't accurate, then I guess you could say there's kind of backup things to help the buyer learn those things before they buy.
Gotcha.
And North Carolina is a closing attorney state, which means we're going to have attorneys involved to help us through. And that's the closing attorney's biggest responsibility, is to do that thorough search of the public records to help the buyer know what they're buying or not. Broker does not sign these. Yes, no, no. All I do is play delivery man. I'm going to help get it from the seller to the buyer. I'm not signing anything. I do not touch this form other than say, here you go. Fun fact, heading out to break. We've said most of our pre-printed forms come from NC Realtors, NC Association of Realtors. The Real Estate Commission gives us 3 forms. The Real Estate Commission gives us the RPODs, they give us the MOG, and they give us the Working with Real Estate Agent disclosure. Everything else comes from NC Realtors. So there's your fun fact as we go into break. Let's take 10. We come back and we'll say more about the act. Go back. So I am taking attendance. Let's talk more about this Disclosure Act. So the RPOs and the MOG. I'm going to advise the seller of their disclosure requirements. I'm going to let them know they can't lie. Nobody, I don't care who you are, seller, broker, whatever. Nobody has a golden ticket to lie. So if the seller feels tempted to lie, we need to advise them not to. We need to advise them that if they are found in a lie, this could turn into a civil thing after closing. The buyer could go after the seller for that lie. Again, how far are they going to get? I don't know. It depends on the attorneys. It might depend on the judge's mood that day. But usually if you tell people that there's the chance, and look, if they got a lot of questions, like, what do you mean they can sue me? Then get them to the North Carolina General Statute or advise them to talk to their own attorney. So I'm going to let them know their requirements, mandatory form, optional disclosure, and let the seller know that they don't have to disclose anything if they don't want to. They have every right to say no representation. The continued need for accuracy. So listing agents, we have our sellers complete these before we list the property. And maybe they say, yes, something is broke. And then they fix it. We need to do an updated RPOs. If the seller says, nope, this isn't broke, ship shape, and then it breaks, we need to do an updated RPOs. We have a duty as brokers to keep this thing accurate throughout the listing period, from the listing to the closing. If anything changes in the home's conditions, then we need to have our sellers update the RPOs, acknowledge that change if they have said yes or no to begin with. If they originally said no representation, then there's nothing to change here. So we have a continued need for accuracy. Another thing we're getting ready to talk about is disciplinary action. And I'll tell you guys, I've seen this pop up more and more recently with disciplinary action. Broker failed to have the seller update the RPOs. Condition of the property changed. So we got to be talking to our sellers throughout the listing, right? It's not like I'm just not going to talk to you when I list it and then call you when it's time to go to closing. I mean, we're going to be in touch with them throughout the whole listing period. So making sure we keep that thing updated should the condition or conditions of the home change. We're going to assure timely delivery. Again, we don't want the seller to lose the buyer. I mean, right now we're in a seller's market, so it's not as big of a deal. But what if we were in a buyer's market? What if it took us 6 months to find this buyer, and then your seller doesn't do the RPOs and they're going to walk away? When are we going to find that next buyer? But either way, we have that buyer. So we're going to make sure that we assure timely delivery to the buyer, so we don't give that buyer that out. We don't give them that option to terminate if they choose. Yeah, Brittany.
So back to the accuracy and keeping it ongoing.
Mhm.
Let's say there is an issue where they had no, inspector comes out, there is an issue, issues fixed after inspection. That would be when you would update that before.
Yes. Yeah. Or maybe the seller didn't know and they said no. And then we had the home inspection and the buyer chose to share that home inspection with us. Seller said, I didn't know this was an issue. I didn't know this was broke. Okay, maybe we need to update. And again, Brittany, maybe we're, having these conversations early on when, before we do the form. Like, look, if you genuinely don't know, your best bet is to say no representation. I'm not encouraging no representation. I'm letting them know their options. And saying no rep is better than lying, right? whether you know it's a lie or not. I mean, guys, does this surprise you? It may not surprise you how many homeowners don't go into the crawl space, how many homeowners don't go up in the attic. Look at you guys. You're like, no, I don't go up there. And I hear you. I hear you. But every once in a while, it would behoove you to like poke your head up there, right? Poke your head in the crawl space because things go on in those places, whether you see it or not. So it might be you've lived here for 12 years and you haven't looked in the attic in 11 and a half, right? Your best bet might be to say no representation because you just don't know. But what we need to understand as brokers is if there is things that change, then we need to hand our sellers a new blank ARPOs and say, you got to do this again. You got to update this thing again. And again, I'm not doing it for them. I'm not telling them how to do, oh, just say no representation and you'll be fine. No, I'm giving them their options. You have the option to say yes. You have the option to say no. You have an option to say no representation. The previous ARPOs that Brittany was referring to, I said font 6, and that may not be accurate, but I'm not too far off. It was itty bitty. And I had a seller once, and she was selling a rental townhome that she's had. And this woman was probably early to mid 80s. And she didn't have email. So I was at her kitchen table doing all of our listing paperwork. And we came to the ARPOs, and I handed her the ARPOs, and she said, Julie, I can't read that. I said, fair enough. My 30-something-year-old eyes could barely read it, She said, can you? And I said, no, I cannot. But what I can do is I can help you. I can assist you in completing this. And I basically sat there and read for her. She still had the pen in her hand, and I still didn't tell her how to answer. But I pretty much said, this line is about this. This line is about that. She really wanted to disclose what she knew. So she wanted to take the time to go through it. And I was absolutely willing to, belly up to the kitchen table with her and go through that form. But again, I didn't have the pen in my hand. I'm not the one that said you should just say no here or no representation. Everybody with me? That's why these are called seller disclosures. It's the seller's opportunity to disclose. It's the seller's opportunity to tell if they choose. Mandatory form, optional disclosure. So what if we find out that the seller completed it incorrectly? They said, no, nothing's wrong when something is. Again, we need to remind the seller. I mean, I don't know a better way to say this, but if the seller lies, we need to remind the seller that they could be held liable to the buyer after closing. Is the buyer going to pursue them in court? I don't know. But what I do know is they could. If they do discover the lie, they could. And remember, you guys, once again, I do not care how the seller completes this form. Welcome back. I don't care how the seller completes this form. I always have a duty to disclose material facts. And the seller needs to know that. Thank you. The seller needs to know that going into it. Remember, I'm following their lawful instructions. So when they say structural issues can only be detected in the deep, dark corner of the crawl space, shh, don't tell anybody. We've already had that conversation that I have to. Seller says no representation and doesn't wish to correct the issue. What can I do? All I can do is disclose what I know, regardless of how the seller completes the form. We disclose what we know. And then, like we said, if they say, yes, there's an issue, and then they fix it, or if they say, no, no issues, and then it breaks, we need to make sure that we're keeping the ARPOs current throughout the entire listing up to a closing. So if ever there's a change in the ARPOs or a change in the property, would require a change in the ARPOs, and we just need to make sure that we're having them update that, providing any prospective buyers. Maybe somebody's thinking about it. Maybe you have a buyer under contract. By the way, guys, the sellers just fixed this. Here's the updated RPODs. Maybe the seller's even willing to share the receipt for who fixed it, how it was fixed. Just a conversation you can have with your seller. Questions on the RPODs or the MOG? I've mentioned a couple times disciplinary action. Any liability for breach of your agency duties, any liability for breach of duties spelled out in our agency agreements, any liability for breach of our duties under OLCAR, that common law of agency, any kind of breach of duty could result in some disciplinary action. It could also result in some criminal or civil charges as well. So I need you guys to understand a couple things going into this. The North Carolina Real Estate Commission is responsible for your license. The Real Estate Commission giveth you your license, and guess what? They can taketh it away. The Real Estate Commission is not going to fine licensees. They're going to discipline your license. There's only one time, there's only one broker, one licensee that can be fined. Does anybody remember who that licensee is? Who's the one time that the Real Estate Commission can fine?
Timeshare.
Our timeshare developers. Yep, good job, Heliana. The Real Estate Commission can only fine timeshare developers. Head bobs, everybody's hearing me. That's the only time they can fine. The only times they're going to get involved with matters of money. They can't make you pay anybody back. They can't make you fine. They can't make you reimburse your commission. The Real Estate Commission is a licensing body. And if you get yourself in trouble with the Real Estate Commission, they can discipline your license. To discipline your license would be to reprimand it or censor it. A reprimand or a censor is like a slap on the wrist. Don't do that again. Maybe what you did to get yourself in trouble was an agency violation. So they're going to make you take an extra CE class on agency, right? Or they're going to make you go back and take the post licensing class on agency. They've slapped you on the wrist. They said you need some additional education to ensure that this doesn't happen again. If they suspend your license, it could be for a period of 2 months. I've seen it up to a period of 2 years. What kind of brokerage activities are you doing on a suspended license? I got head shaking no, and you're right. When your license is suspended, you're not working during that time in real estate, in a brokerage role. They could also revoke your license, which means they could flat out take it back. So let's talk about this disciplinary action. Any consumer can file a complaint. As a matter of fact, if you go to ncrec.gov, which we're going to go out and check out next week, actually, but on the home page, y'all, on the home page, there's a big button that says file a complaint. It's so easy for the consumer to find. It's so easy for the consumer to file a complaint. So the consumer clicks on file a complaint, and they have a template they have to fill out. What was the issue? What was the complaint? What was the violation? Who's the agent? You know, what's all the information about the complaint? The Real Estate Commission reviews it and makes sure if this even is a violation of license law and commission rule. You know, Yelp has made us all online critics, right? So it might be that the consumer is complaining about something that's not a violation of license law and commission rule. My agent never returned my phone calls. Well, that's just rude, but I didn't violate license law and commission rule. Everybody with me? So the first step is determining if there is a complaint warranted. If the commission determines that there's a possible complaint, the next thing they're going to do is send the broker and possibly the broker in charge a letter of inquiry. The letter of inquiry is your opportunity to respond to the complaint. They're not saying you're guilty. They're just saying there's been a complaint filed against you. What is your side of the story? The Real Estate Commission understands that there's 2, sometimes 3 sides to every story. So the letter of inquiry is your opportunity to respond to the complaint. And how do you think you're going to have to respond? What is your response? Am I going to be able to call the commission and say, I didn't do it? That's right. My response is my documentation. What do we document? Every stinking thing. They're going to want to see your agency paperwork, working with real estate agent disclosure and your agency agreement, any other forms that are related to the complaint. They're going to want to see your text correspondence, your email correspondence, any communication, any documentation that relates to this complaint. And guys, your documentation is the only way you can respond. So if you don't have any documentation, you're not off to a good start. Everybody hearing me? What do we document? Everything. We have cloud storage now. I don't think we have to worry about running out in our lifetimes. So you know what? Fill it up. Fill it up. Let our kids worry about what they're going to do with their storage. But now we're going to use ours, right? Okay. So you respond with your documentation, any requested paperwork, applicable communications, etc. The commission reviews your response and they either determine that what they have is sufficient, or maybe they come back to you for more information. But once they have fully investigated the matter, at the end, you're either going to be told you're guilty of, and these are the consequences, reprimand, suspend, or revoke. Or they're going to say, thank you very much for your cooperation. This matter has been closed. But they're going to want to see everything, and every single disciplinary action is handled on a case-by-case basis. So I can't tell you guys, if you do this, they're going to do that, because it's all a case-by-case basis. Remember, in the commission's main purpose is to protect the public. And bottom line, they want to know, how badly did you harm their public? You might, in the midst of this investigation, be asked to go to Raleigh and stand in front of the commissioners. They want to hear you. They want to see you. They want you to stand in front of the commissioners for your side of the story. You guys always remember, at any time in this process, from the letter of inquiry on, you're always welcome to have your own representation. And if you have to go to Raleigh to stand in front of the commissioners, I highly recommend you take your attorney with you. If you've made it that far, I'd so much rather have an attorney standing next to me when I'm standing in front of our 9 commissioners. The other option, all licensees have the option at any time during the investigation to surrender their license. So if you're guilty and you know in your heart of hearts that you're guilty, you might be able to save yourself a trip to Raleigh and just surrender your license. You need to decide what to do. If they found that disciplinary action is necessary, again, they can either reprimand, suspend, or revoke your license. The Real Estate Commission publishes an e-bulletin once a month. And there's so much good information in the e-bulletin. You guys will sign up for it. You know, maybe next week when I show you, maybe when you get licensed, but you guys will get the e-bulletin, and there's many good tabs, much good information. And one of the tabs every month in the e-bulletin is a tab that says disciplinary action. And when you click on that, it gives the world your name, your city, your firm, what you did, and what they did to you. How's that make us feel? And they publish it in the local paper. So now grandma knows about it too. Are you kidding me? You're not going to get away from it. You're not going to get away from it. So how do we avoid this? License, law, and commission rule. That's what this class is all about. I say my job is to get you through your state exam, but I don't think that's accurate. I think my job is twofold. Big part of my job, get you through your state exam. The next part of my job is to help you keep your license once you get it. And how do you keep it? How do you stay out of disciplinary action? That's what this class is all about. That put a little bit of fear in you? Every month. So when I said earlier, I've seen the RPODS thing come up, it's coming up in the disciplinary action. Listing agent neglected to update the RPODS. I'm seeing this. The commission's not calling me and telling me what they've disciplined. I'm seeing this as a member of the public. I'm seeing this action every single month. And by the way, when I, as a broker, once you get that e-bulletin, the first place you're going to go is the disciplinary action, because that's just what we do. You want to see who you know. And yeah, you're going to see people who you know. And remember, you're human too, you guys. You're human too. They just got caught. If your license gets revoked, is that permanent? Yeah. If it gets revoked, they're taking it back and game over. It's a career changing event because you're done with brokerage activities. Other questions about the disciplinary action? The other option that the injured consumer has then, they could file a complaint or they could also get an attorney to sue you. The court is where the fines come from. The court is where the money damages come from. They could hire an attorney and the attorney could recommend they file a complaint. They could file a complaint and somewhere along the line, they might decide that they need an attorney. It's really up to the consumer how they proceed. But no, for our standpoint, our point of view, we could be facing the commission. We could also be facing the judge. I feel like you've really messed up when you're facing both of them. And again, how do we prevent all this to begin with? License, law, and commission rule. That's why you guys are here. Y'all are working very, very hard to get your license. So let's work really hard to keep it once we get it. Fair enough? It's so simple, you guys. When in doubt, find out. Another one of Julie's super simple philosophies. When in doubt, find out. The resources are out there. The tools are out there. I'd rather take time out of my life to do it right, to learn how to do it right, than have to face anything I'm looking at on my screen right now. Is that fair? Questions on the disciplinary? Every spring, the North Carolina Real Estate Commission has a conference for educators. So we all get together and go to Raleigh. We're going in a few weeks. We don't have class that day. I'll remind you. I can't tell you the date off the top of my head, but I'll remind you. And one piece of material that I get every spring from the commission that I really, really spend time on and focusing on is they actually release the disciplinary actions for the previous year. So this is the 2021-2022 year. The 23-24 year looked similar. We are about in the 24 to 25 year. And this tells us what is it that got agents in trouble? And y'all check out almost half. This is a great segue into our discussion on the importance of disclosing material facts. And y'all, it was the same thing the year before and the year after. Material facts have been a hot topic for years now because of the disciplinary actions. Consumers are calling the commission and feeling they weren't properly presented with material facts. And after an investigation, they were proven right. Can I just say half? I think the next year it was like 48%. So can we just cut hairs and say half of the disciplinary actions are material facts? So with that being said, let's talk about material facts. We've danced all around it. So now we're going to hit it head on. First off, when it comes to material facts, I have a duty to discover and disclose. Please make a note. I do not diagnose. My job is to say, hey, look, that caused me to have a red flag. Maybe it's a stain on the ceiling, a crack in the wall. I don't know, a leaking something. Anything that you see is going to be considered a material fact. We have this duty not just to disclose it, but we're going to help our clients discover it. And I help them by discovering it by identifying my red flags. Hey, look, there's a stain on the ceiling. Let's talk to somebody, the professional, to find out where that came from. Is it a leaky roof? Is it a faulty plumbing from a second-story bathroom? Is it because it's the cat's litter box is on the second floor up there and the cat misses? It has bad aim. I don't know what caused it. And that's not my job to tell you what caused it. My job is to say, hey, look, stain on the ceiling. Let's investigate it. We discover and disclose. We do not diagnose. Stay in your lane. Even if the property is being sold as is, y'all, all homes in North Carolina are sold as is, whether they're advertised as is or not, which means the seller doesn't have to fix anything. Sellers got it made in North Carolina, don't they? This is what caveat emptor means. They don't have to disclose much and they don't have to fix anything. They might agree to do a repair. We'll talk about how that's going to look when we get to our contracts. But all homes are as is, whether they're advertised as is or not. So, what in the heck is a material fact? Well, the definition of a material fact is very broad and quite frankly, not helpful at all. The definition of a material fact is an important fact that the property that may affect a person's judgment. Well, what does that mean? Is something that could be important to me may not be important to you. Is something important to you may not be important to that other person. So the broad definition of material fact is not really helpful. So what the commission did to help us out is they honed in, they narrowed it in, and they gave us specifics. The Real Estate Commission specifically has defined a material fact. It's a fact about the property itself. Something's leaking, structural issues, plumbing issues, electrical issues. It's something about the property itself. You know, something that would prohibit somebody or may cause somebody to think before buying this home. Let's say my ceiling fan blade is a little wonky and it causes my ceiling fan to tilt slightly. Is that something to get excited about? Whatever, it's a wonky ceiling fan blade. That's different than structural issues, plumbing issues, electrical issues. There's no such thing as a perfect home. All homes have issues. Some of them are whatever. Some of them are a material fact. When in doubt, disclose. So material fact, the commission defines a fact about the property itself. Also, a material fact is a fact relating directly to the property. A proposed zoning amendment, NCDOT wants to widen the road in front of the property. They're going to redraw the school lines. It's not on the property, but it's related directly to the property. Where are my Kernersville people? Anybody from Kernersville? One of you? Two of you? All right. You know that dang belt loop they've been building for the last how many years? You know how many properties have been affected by that belt loop because it was related directly to, it was close. And it's my duty to disclose. NCDOT is building a belt loop 0.8 miles from this home you're thinking about buying, for example. The commission also defines a material fact. It's a fact affecting the ability of your principal to complete the transaction. This is the one that causes the most confusion. Didn't we just get done preaching about old car and that C in old car being confidentiality? And now I'm telling you that it's a material fact, which means I must disclose if my principal can't complete the transaction. Let's say we're under contract and we find out our buyer's not going to get loan approval. Or we're under contract, or we even have it listed close to being under contract, and the seller is now in foreclosure. If your principal can't complete the transaction, it's a material fact because it affects the other side. If your buyer's not going to get loan approval, doesn't that affect your seller? If your seller's losing the property to foreclosure, that affects your buyer. So I owe my parties confidentiality. You better believe I do. But if it's something that affects their ability to complete the transaction, that's now a material fact that I have to disclose to the other side because it affects. And this is where the seller is going to look at you and say, man, I'm in foreclosure. Please don't tell anybody. I have to tell the other side, but I promise I won't tell anybody else. The fourth thing defined as a material fact is for me and you, for the brokers. A material fact is the specific importance of our principal. Another one of Julie's super simple philosophy. If it's important to my buyer, then it's important to me. If it's important to my seller, then it's important to me. Once my buyers or sellers share with me something of specific importance, once they share with me something about them that is important to them, I now have a material fact on my hand. I now have a duty to make sure that their specific importance can be met. When we talked about zoning, we talked about that buyer that wanted to convert the garage into a hair salon. When the buyer tells me that, I now have a material fact on my hand. I have a duty to verify zoning will allow it. I have a duty to verify that the covenants will allow it. My seller says, if you can't sell my house for me to make X amount, is that not something that's specific importance to them? I'm not going to sell my house if you can't make me $50,000. We now have a material fact on our hands. Because of all the disciplinary actions, we've seen material facts have been the main topic in CE for the last, I don't know how many years. And I heard last year, the year before, a very interesting perspective about how specific, about how important these things can be. And they were sharing stories with us. Let's say you have a buyer that has a very sensitive, a high allergy to dogs. And they say they can't live in a home that's had a dog in the home. Do you, the broker, now have a material fact on your hand? Do you have a duty to call the listing agent before every showing and say, hey, real quick, does your sellers have dogs? What if the buyer says they won't live in a home that's been smoked in? Don't you owe it to your buyer to pick the phone up and call the listing agent? And the reason we do is because if it's important to them, then it's important to me. If they share something with me, I now have a material fact on my hand. I now have a duty to make sure that that end use is going to be met. If it's important to them, then it's important to me. Now, I'm not going to run around advertising. My buyers won't live in a house with dogs. But I am going to make sure, to the best of my ability, I'm going to pick up the phone, I'm going to call, I'm going to ask some questions on their behalf. Questions just so far on the specifics, the things that the commission has identified as material facts.
I have a question. So say a buyer says they don't want to live in a house that had dogs, like you said, right? Okay, they're not gonna like that. The dog's not gonna be there when they move in. So like, even though I
Their,
might close,
their dander, their skin, their smell,
true.
that's what they're allergic to, is that dander. And if
And
they have severe allergies, a deep clean may not
do it.
suffice, you know?
Yeah. Okay.
Maybe they just don't like dogs. I don't know. Maybe they just don't like dogs
But
and they don't want to be anywhere near a dog, you know, but once they share it with me, it's now important. I did an open house once and the house was immaculate. I don't know how many dogs they have, but you wouldn't know by looking at the house. You couldn't smell anything. Some people take better care of their pets than others. You couldn't smell anything. You couldn't, you know, you couldn't tell. The only way you knew that there was a dog there at one point was in the far back corner of the backyard was a dog house. And at the open house, a couple came in looking around, no problems. And then they walked out back, saw that dog house, and said, nope, we're done. Thank you very much for your time. Now, I was just doing an open house. I was representing the seller, so I didn't ask a lot of questions, but it was enough for them. Just seeing that dog house was enough for them to know we thanked each other for our times, walked out of each other's lives, and that was that. If it's important to them, then it's important to me.
Okay, I have a question because in their laws and commission rules comments, it uses the example such as the buyer wanting the ability to add a pool. So let's say they're in a subdivision, we check with the HOA, they can have a pool, whatever else comes with that. But then when it comes to the actual pool itself and digging in the ground, they see underground piping or something, they run into an issue in that process. We did our discovery and our research, but now is that where we could have this claim of, I guess, a complaint filed with the commission in
Would
that?
they file a complaint? Yes. How far are they going to get? I don't know, because I only can disclose what I know or what I should reasonably know. So I've done my part. I made sure zoning allowed it. I made sure HOA allowed it. The only way to know that there's pipes under there that would prevent them from building a pool is for me to show up with the backhoe and start digging. And I'm not required to do that, right? And that's why we call like 811 before we start digging, you know, and maybe we talk to them. Maybe we have them come out if that's a concern. But Brittany, that's a great point. And I can only disclose what I know or what I should reasonably know. You know, I need a fence. You know, all those dogs, I don't want them inside all the time. I need a fence. Can I put a fence up? Oh, look, the neighbors have a fence, so I'm sure I can put a fence up. What do we know when we see a fence? The only thing we know is that somebody put a fence there. And if your buyer's thinking about putting a fence up, I'm going to make sure it's allowed for the covenants. We're not going to do what the Joneses are doing. We're going to make sure that the covenants allow it. We're going to make sure that there's no violations. You know, some covenants may say a particular material. Some covenants may say you can't have a chain link fence. It's only a vinyl or a wood fence, right? So they might get very specific. Well, I wanted a chain link fence. Well, then this isn't the property for you. Let's keep looking, right? I'm helping them learn. I'm helping them discover and gather that information. But I can only help them with what I know. If they don't share their wants and needs with me, then I can't help them. And this takes us back to buyer consultations, wants and needs list. That kind of helps get some of these things out so we can ensure that that end use, that end product can be met. Yeah, Ebony.
Back to the dog situation. If I remember, I had this client from doing CNA work. They had 14 collie dogs, and they was hoarders. Now, even if they somebody like that sold their home, um, and they got Molly Mays to clean it, there's no way you could hide that from the buyer, potential buyer, because of how many dogs they had. If just
I don't like that you're trying to hide stuff, but you know, the buyer may want a deep clean, right? Once we get
right,
the
and
14 dogs out, the buyer may request a deep clean, and that's something we can negotiate. The seller
okay,
may
okay,
offer, I'm going to get new carpet, new padding,
mm-hmm,
paint, and I'm going to do a deep clean once we get out. Awesome. Now we
okay,
have information to deal with.
okay.
But if the
Thank you,
the
Mr.
seller also has the right to say, I'm not cleaning nothing. I'm moving me and my dogs and my hoard out,
Mm,
and the rest of it is on you. So now the buyer has a decision to make, right? Either you proceed to buy this home or we keep going.
okay.
So everybody good so far? I got 4 things specific. If you Google material facts, you're going to get this very broad. What the heck does this mean definition? So the commission helps by honing and narrowing in on specifics. Does everybody have these written down? Remember, half of the disciplinary actions are about what we're looking at right now on our screen. If you don't have it written down yet, take you a quick screenshot. Super quick. I'm getting ready to change slide. Everybody ready? All right. So, if the property is in a flood zone, listing agents, before you list the property, we need to determine if it's in a flood zone. We can look at a flood map. We can straight up ask the seller. That's in our questionnaire in the listing agreement. Is the property in a flood zone, and do you require flood insurance? Just because it's in a flood zone doesn't mean flood insurance is required. So if it's in a flood zone, we're going to disclose that. Again, any major defects on the property. You know, when you talk about foundation, roof, plumbing, electrical, there's hefty price tags involved in that stuff. And a buyer needs to know, if I'm going to buy this house and there's structural issues and the roof is 35 years old, they're going to have to take into consideration that sooner rather than later, they're going to need a new roof. They're going to have to deal with these structural issues. Sellers in foreclosure. Again, there's a difference in default versus foreclosure. But once that seller's in foreclosure, the wheels are in motion, and that is a material fact. The courts may not have seized the property yet, but the wheels are in motion. So the North Carolina General Assembly, we're going off the commission. We're going straight to state law now. And the North Carolina General Assembly gives me a couple things that will always be a material fact. Like, you don't have to stop and ask yourself, gee, I wonder if I need to disclose this. If you come across it, state law says, yes, we're always going to disclose it. So the first thing that the General Assembly addresses is polybutylene pipes. Polybutylene pipes is a plastic pipe. The construction is not meant to last forever. The old joke is, if polybutylene pipes haven't leaked yet, they will. The General Assembly says, once a polybutylene pipe has leaked, even if it's been repaired, once it's leaked, it will always be a material fact. But make a note, It's not a material fact until it leaks. So once it's leaked, even if it's been repaired, it will be a material fact. And you can tell polybutylene pipe, and this is under a crawl space. You can see the rafters, and it usually has it's plastic, and it's got like white letters or red or blue, but you can tell plastic versus steel corroded, right? So if your flag goes up, we got to ask some questions. And it's not just a matter of the pipes coming out of underneath the kitchen sink or underneath the bathroom sink. It's what's coming from the ground, what's underneath the home or near the home that connects it to public water, for example. If you're listing a townhouse and the neighbor had a leaky polybutylene pipe, then we should disclose that, because again, you guys, the old joke is if it hasn't leaked yet, it will. But I don't have this duty to disclose, or the General Assembly says don't disclose until it's leaked. Could I go ahead and disclose it as polybutylene pipes and let them decide? But my duty is not to disclose it until it's leaked. Yeah, hey, Greg.
Does the disclosure apply to commercial as well as residential?
This is residential property. Now, when it comes to material facts, we always have a duty to disclose material facts. So when it comes to material facts, whether you're doing residential, commercial, agricultural, yes, it does apply. Any type of property, whatever your role is, and whether you're talking to a client or a customer.
Thank you.
Yep. Yeah, Dad, hey.
Hi, you had said whether it's repaired or not. Now, if the seller has already repaired it but didn't inform us that there was actually a leak, then how would we know?
I
that
can
there was
only
a-
disclose what I know. I can only disclose what I know.
So they
So-
couldn't complain to the commission that you didn't give them that information if they find out later that there was.
They could always file a complaint, but how far are they going to get with it? That's what you guys are going to ask me. I can't stop the consumer from picking up the phone and filing a complaint. What I'm trying to do is stop them from getting far with it. So if you can say, I had no way of knowing, everything looked fine to me. Now I'm going to ask questions. Have you updated the plumbing? Have you done anything with the pipes? Right? That's my duty to discover and disclose. And if the seller lies to me, I can only disclose what I know. I either need to be aware or reasonably aware. I need to know or reasonably know. Another thing that the General Assembly said will always be a material fact is if the property has ever been clad in EIFS, also known as synthetic stucco. Stucco is an exterior siding. Stucco is the siding. It's real rough looking. It looks like concrete. I tend to associate stucco siding with like Spanish style homes. It looks like the pavement almost. It looks like concrete. Synthetic is fake. So EIFS is fake stucco. It's not the real deal. Somebody somewhere was trying to save money, cut costs, and they put up synthetic stucco. With synthetic stucco, water will get behind it. Moisture will get behind it. And it's going to start rotting at that wood, at the framing of the home. Moisture on a home or any structure is never good. Never, ever. And with synthetic stucco, water gets back there and it gets trapped. And it eats away at that wood, which ultimately affects the property's structural integrity. So if the home has ever been clad in synthetic stucco, even if it's been replaced, once I know, I have a duty to disclose. Again, you guys, you don't have to ask yourself, well, they fixed it and it's now vinyl siding, so do I have to disclose that? The answer is Yes, if it's ever been clad in synthetic stucco and you find out. Now, if I'm looking at a home with vinyl siding, I may not think to ask about synthetic stucco. But guess what? These things we're talking about, these are questions in our listing agreement. So we can look the seller in the eyeball and say, has the exterior ever been clad in synthetic stucco? This is our duty of discovering. We are finding out if there's anything to disclose, and we've got to ask the questions. We've got to ask the questions. So ever been clad in synthetic stucco, even if it's been repaired or replaced, will always remain a material fact on the property. And by the way, the sellers are kind of encouraged to disclose this as well, though they don't have to. They are encouraged to disclose it. Yeah, Annette.
Is these not material facts that are gonna be found during inspection process during
The
that
one-
period where that information is
Possibly.
gathered?
Could be found.
So we're not gonna really necessarily know when we go under contract at that point, but once the inspections are done, once that material fact is given, it's gonna be given to us as well as
And
the buyer at that time, so.
so if the seller doesn't know or the seller doesn't disclose, whatever it is, and then it's later discovered during the home inspection,
Mhm.
you now have a brand new material fact on your hand. Yep. So it's not just about learning stuff at the beginning when I'm listing it. It's if I learn stuff throughout the entire transaction at anywhere during the point the transaction, even if that means looking at the buyer's home inspection, because Annette, if that buyer terminates and you go back on the market, you're now going back on the market with material facts.
So that information I in turn can tell the seller, and now she has to list all of this stuff along with the house. It's not that she did.
The seller doesn't have to disclose anything.
So whatever is found during that process, the seller could still, I mean, their agent wouldn't have to now necessarily know.
The broker has to disclose. But even if I hand the seller a home inspection and say, here's a list of everything wrong with your home, the seller still doesn't have to disclose. Caveat emptor. However, once I get my hands on that inspection report, I now have material facts that I have to disclose.
Okay.
Good stuff, isn't it? Very, very interesting material facts. And I think we're kind of starting, like, this is why this has been the hot topic in CE, because it's so deep, it's so in depth. And you know, guys, I'm gonna, before we go to break, because I got one more to say and we got more to talk about material facts, but I'm just gonna reiterate this. When in doubt, disclose. When in doubt, find out, and then when in doubt, disclose. If you ever find yourself going, I wonder if I should disclose that, just do it. That's the simplest thing, the easiest way I know how to tell you guys. Fair enough? And the buyer's either going to look at you and say, wow, that's really important information. They're going to say, I don't care about that. I don't care their response. It's my duty to disclose. So when in doubt, disclose. I got more to say. We got more material facts, but we also got to take a break. So let's take 10, Excuse me. We're back. I got a question come in. Is it safe to assume material facts is a heavily tested material? I don't know if I'd say heavily tested, but yes, you're going to see test questions on material facts. Unit 3 in general, we see the most of our test questions from this unit. Thank you. So welcome back. I'm going to take attendance, and I got one more thing that's always will be a material fact. So again, they kind of take the guesswork out of this for us. We don't have to stop and ask ourselves. And the other thing, this is the one that gets y'all. The other thing that will always be considered a material fact is if the property has ever been the site, the former site of a meth lab. Now, everybody hear me. I'm not suggesting that you sit at your listing appointment, look the seller in the eyeball and ask them, have you guys ever cooked meth in this home? No, do not do that. However, if you find out that it had previously been the site of a meth lab, again, remember the tenants that have been living here for the last 15 years? What if the tenants were cooking meth? Y'all don't point fingers at the sellers, okay? But are there meth labs out there? Do meth houses go on the market? Do they sell? Yeah, you may come across one. And if you ever come across one, if you ever learn of a previous meth lab, that will be a material fact. Evidently, when meth cooks, it absorbs into the walls, the floors, the ceilings. It doesn't, it's kind of like cigarette smoke a little bit, right? Everything just sucks it all in. And I think you have a hard time getting rid of it. The red flag I have for you, if you walk in the front door and you think it smells like a nail salon, your little red flag just went up. We got to ask some questions. I've heard. But the site of a former meth lab will be a material fact. One that once we find out, we have that duty to disclose. And guys, keep in mind too, some people are looking to buy to flip it. So if there's issues with the home, they're probably breaking, in some cases, they might be breaking it down to the studs anyway, right? So something like mold or previous site of meth lab may not intimidate them. If you have the tools, the equipment, and the knowledge, then these things aren't scary. There's a buyer for every property. There's a buyer for every single property, despite the condition. Some people are more apt. Now, first-time home buyers may not want to deal with this, right? So there's a buyer for every property. It's just a matter of finding that buyer, that sweet spot in the price. So again, just a couple things that the General Assembly says, if you come across them, you don't have to ask yourself, should I disclose? The answer is yes. I just heard something. Who did I just hear?
Me. I was wondering, so I noticed that I didn't see anything on death. We don't have to.
I'm getting there, actually. Hang on to that, Brittany. We're going to talk about death. Yep, getting there. Because that's a question you're going to be asked. You don't have to show many homes before a buyer looks at you and says, anybody ever died in this home? So yes, we are going to address that. So what's all this mean for us? Are y'all dreaming about this yet? When it comes to material facts, I have a duty to discover and disclose. Do not diagnose. Stay in your lane. Even if you've had a similar experience at a previous transaction, what if you had a similar experience with your own home and you are well involved with that process? Maybe the roof leaked and you had to get a new one, and you know that doesn't make you a roofer. That doesn't make you a general contractor. Stay in your lane. Look for those red flags, ask the questions, encourage the investigations and the inspections. And when, no matter how you learn about it, when you learn about it, We always have a duty to disclose. Also for brokers.
Okay, question. Because I
Yeah.
know we always have the duty to disclose. I get that. So what if it's something that you did not know? You've done your job. You've done your job.
Then,
All the right.
then you have nothing to disclose.
Yeah,
I can't know everything about this home. I just saw it along with you, right?
but I mean, like we're like right in closing, and I just found out something right before I walked in the.
Disclose. So you walk into the attorney's office and you say, hey, y'all, guess what I just learned?
Even though we're about to go into signing.
Yep.
Okay. Okay.
Could it prohibit the buyer from buying? Because guys, in North Carolina, once the buyer signs, the house and all its problem is theirs. So they need all of the information before they sign. Even if you learned about it on your way to the closing table, we still
And
have a duty.
what
to
happens if I
disclose.
learned about it after they sign?
Well, agency's over at that point, right?
Okay.
Now, why are you trying to discover stuff after? You
No,
with
I'm
me?
not-
Why are you learning
but-
stuff after?
Yeah, no, I definitely want to do my job. I'm saying like just
And I'm not saying you're not, but you're hearing me, right?
yeah.
We're, by the time we're done, by the time we're closes it, we're done. We've moved on to the next.
Yeah. Okay.
And if it might be a courtesy call. Hey, former client, I just listed the house across the street, and guess what the neighbors told me? Yeah, I mean, a courtesy call is okay, but now you're going beyond agency duty. Remember, you only get OCAR from me when we're in that agency agreement. And we always have that duty to disclose material facts. So yesterday you were my client, today you're my customer. We always have that duty. So brokers, we're going to identify property conditions that warrant further inspections. Again, I'm not going to say, well, clearly the roof is leaked, so you guys are going to have to get a new one. Or I'm not going to say a patch job is required here. What I'm going to say is this roof threw up a red flag for me. So I suggest that you talk to a roofer. The electrical threw up a red flag for the home inspector. So I suggest that you talk to an electrician. I'm not telling you what I know or what I think I know. I'm telling you, the buyer, to have further inspections, to get your questions answered by the pros. Based on our clients and customers' proposed use, we're going to help them identify issues with land use control. So this gets us back to zoning and covenants. So again, if it's important to them, then it's important to me. And if they say they have a specific land use or a specific use for the property, I have this duty to make sure that zoning will be okay. And also covenants if it's in an HOA. And then we have a duty to avoid misrepresentation or omissions of material facts. We're going to break that down a little bit further. We're going to talk about misrepresentation and omission because those are the two things that get agents in trouble with material facts. You either lie about it or you don't say anything at all. So we're going to spend a little bit more time on that. And listen, I know you guys are very concerned right now. Like, how do I know all this stuff? How do I learn all this stuff? And guys, this is why we constantly need to be on the lookout for our little red flags. Constantly. If something doesn't look right or normal or as it should to you, my little red flag went up. And what I'm going to tell the client is, you should look into this further. What they do with that information is not on me. Remember, I'm a fact finder. I provide them the resources. I provide them the information. So let's say, for example, you are at a listing appointment and you've gotten a listing. Congratulations. And you and the seller are walking through the home together and you're looking at the features. You're discussing the features of the home so you can list it. And you guys walk into the kitchen and you do a quick scan of the kitchen and everything in that kitchen looks normal to you. Now, I'm not a kitchen expert, but I know what my oven at home looks like. I know that my refrigerator, the doors are sealed, right? I know what looks normal for kitchen appliances and what doesn't. And then I'm going to ask the seller, is there any issues with the appliances that are going to convey? I've asked the question, I did my scan. The seller says, nope, no issues. And I'm going to say, awesome, let's move on to the next room. Didn't I ask the questions? Didn't I do my own scan? It's not like I have a duty to say, when the seller says, no, everything's fine. It's not like I'm going to say, well, I'll be the judge of that and go over and start turning on all the burners and making sure that the oven heats to the right temperature, right? If nothing looks out of sorts to me and the seller says everything is fine, moving on to the next room. What if the seller says everything's fine, but something doesn't look normal to me? I'm not an oven expert, but I know my oven at home, the door is straight, it's secure. But what if this oven is a little cockeyed? Is that normal? Is that how your oven at home works? You can't retain heat if it's not, right? That should throw a red flag. Really? There's no problems with the oven? The door's not on right. The door's not secure. That's what we're looking for. And when something looks out of sorts to you, that's going to throw up your little red flag. That's going to prompt me to ask some questions. The one thing that we cannot do when it comes to material facts is be an ostrich. I cannot walk into a room not looking, not smelling, not seeing, like, oh, everything looks fine here. I can't bury my head in the sand. I can't not discover. I can't not look out for those little red flags. And just because I see a little red flag doesn't mean there's an issue, because I'm not the expert here. I'm not diagnosing. I'm just on alert for those things that look unusual, those things that don't look normal. Maybe you learned something about your own oven by looking at everybody else's. I don't know. Maybe you're the one that is not normal, but things that stand out. And that's where you and I, when we walk through a home, whether we're with sellers or buyers, when we walk through a home, we need to look up. We need to look at the walls. We need to look at the floorboards. We need to look at the floors. We need to be looking for, that's our duty to discover. And when something looks out of source, we have a duty to say, my little red flag went up. I think you should have this inspected. I think we should find out more information. And again, what the buyer does with that, that's on them, or the seller, that's on them. All I can do is advise. I have, and it's a really good article. It's not required. I mean, nothing's really required in this class, but in our Google Drive, I have an article from the commission, and I think this might help if you guys, so there's a couple. There's one straight from the bulletin that we just talked about that addresses the question, what is a material fact? And it does that breakdown of the 4 specifics that we just looked at. But the other article in our Google Drive that I'm a really big fan of is also from the commission, and it's titled, What is Common Knowledge? So this is going to help answer many of your questions. How am I supposed to know this stuff? How am I supposed to know if something's broke? How am I supposed to learn about these material facts? And this article about what is common knowledge addresses that as it relates to material facts. So I do recommend, and this one's only what, 3 pages? I do recommend that you guys read this. Again, both of them are in our Google Drive, both straight from the North Carolina Real Estate Commission e-bulletin. You're looking for things that you should know or should reasonably be able to find out. And one of the best way to find out stuff is to ask questions. Team had a listing. Agent did their duty as a listing agent. They looked through the home. We have a general rule of thumb when it comes to attics and crawl spaces. They call that the head and shoulder rule. As long as you poke your head and shoulders in with a flashlight, we're not expected to go in the deep crevices of the crawl space, stuff like that, right? But as long as we just kind of poke our head in with the flashlight and look around, So we listed the property, we went under contract. The buyer's home inspector discovered a structural issue. They decided to have a structural engineer out. And based on what the structural engineer said, the buyers chose not to buy. We went back on the market. Don't we now have a material fact? We now know stuff about the structural that we couldn't of, but now we know, and now we're back on the market. Now, you pull this listing up, you're not going to see it in the remarks. It's not going to lead with major structural issues. But when an agent schedules a showing, we're going to reach out to the agent and say, by the by, the previous buyer, the previous contract, this is what they discovered. Again, the vehicle for delivering this information does not matter. It's really rare that you see lots of problems with the home in the remarks, because we usually use the remarks to sell the property, not list off all the problems. So maybe we reach out to them, maybe we email them when they schedule the showing, right? We have an agent only. So there's other ways that we can disclose this information. But guys, we're back on the market. The buyer terminated because of structural concerns. And we're back on the market with structural material fact, because now we know. What's that old saying? If you see something, say something. We need to have our ears open, our eyes open, our smelling senses open. Sometimes smelling can lead us to throw up the red flag, to ask some questions. So now that we know what material facts are, let's talk about, when it goes wrong. What can we get in trouble specifically for material facts? And we're going to first kind of define some words, and then we're going to do a mashup. So let's just define some words first. Willful versus negligent. The difference in the two comes down to intent. A willful act is one that is done intentionally. It's done on purpose. You have actual knowledge. You knew. Compare that to a negligent act. A negligent act is by mistake, or maybe you didn't take the time to look it up. You were negligent in learning about your material facts. So willful, which one do you think will get you in bigger trouble at the commission? A willful act or a negligent act?
Willful.
Willful, I would agree, because you knew. Negligent, y'all, we're all human. Every single one of us are human, including our commissioners. Negligent acts happen. When you find out you make a mistake, just make it right. Just fix it. So acts are either willful or negligent. When it comes to mishandling material facts, it's either a representation or an omission. And the difference of these is whether you said something or not. A misrepresentation, please write this down for me. A misrepresentation is a lie. It's a nice way of saying you lied about the material fact. Maybe you vocally said it in a conversation. Maybe you put it in an email, a text message. Maybe it's misleading information in your advertising or your remarks. If you misrepresent a material fact, you have lied about a material fact. Compare lying to not saying anything at all. You kept your mouth shut. You did not disclose. You knew about a material fact, or reasonably should have known about a material fact, and you chose to keep your mouth shut. So now that we've just defined some basic words, we're going to do a mashup. The mashup is what I refer to as the big four. If you're going down for material facts, it's because of one of the big four. So what are the prohibited acts about material facts? First is a willful misrepresentation. It's an intentional lie. You knew and you lied. You knew the home has major structural issues because the buyer that just terminated sent you the home inspection report. Don't you know? And now we're back on the market, and the next buyer says, are there any major issues with this home? And you say, you've just engaged in a willful misrepresentation. You knew and you lied. Next up of the big four is a willful omission. You knew the structural issue because you got your hand on the home inspection report. Now, I'm not saying release that report. That's not your report. But can I disclose the information in the report? Can I disclose those material facts? So you knew there were structural issues, but you chose not to disclose. You didn't tell. And again, the vehicle doesn't matter as long as I get it out. If you don't email it, if you don't text it, if you don't pick up the phone and call, then you have omitted that material fact, and you did so willfully. You knew and you kept your mouth shut. When it comes to real estate, this is not a don't ask, don't tell, because we always have a duty to disclose material facts. I don't have to wait for the buyer to ask. So even if the buyer doesn't specifically say, are there structural issues? I still have a duty to share. I still have a duty to disclose those material facts. So willful acts are those done intentionally. They're done on purpose. You know, and you still willfully acted. Either you lied or you didn't say anything at all. You kept your mouth shut. Negligent acts then are an accident, but guess what? They still happen. So negligent misrepresentation is an accidental lie. You weren't aware of the material fact, or you did not know, but you still put out false information. Y'all don't answer questions until you know. And let me tell you guys, I don't know, let me get back to you is a perfectly acceptable answer as long as you plan on getting back to them. When it comes to negligent acts, we've already decided willful acts are more severely punished. But when it comes to negligent acts, the Real Estate Commission quite often will perform what's referred to as the reasonable standards test. And the reasonable standards test answers the question, could the broker have found out? If they went to this website, could they have found out? If they asked the seller questions, could they found out? Let's say, for example, this is something about zoning. Can't you go to the website and get your answer? Y'all, if it's something about zoning, you know the first place that the Real Estate Commission is going to go? To that zoning board's website. And if they can do a quick Google search and find out, doesn't the reasonable standards test say that you could have as well? If it's information we can find out by asking questions. So negligent acts are not as severely punished, but the difference is whether you could have found out. Did you take the couple extra steps to find out? So negligent misrepresentation, it's an accidental lie, but you still put false information out there. And then the big four that we have is the negligent omission. You did not disclose. Maybe you didn't know, maybe you weren't aware. You did not put the information out there. And again, the commission's going to ask, could they have found out? They kept their mouth shut, but is this something that they could have found out, that they could have discovered. And with so much of this information online now, I really feel confident that that's one of the first places the commission's going and determining the reasonable standards test. So if you don't go to NCDOT's highways website and determine that they're going to build a belt loop two properties down, and they do, how's that look for you? Is everybody with me? Guys, we got to do our research. We've got to do our homework. And when I say document everything, I don't know, maybe I'm a little overboard. But if I'm sent to the tax records to look up this year's tax bill, oh, I'm printing it out and I'm putting it in the file because that shows the date, the time that I put my eyes on that. Does that make sense? I might be a little overboard in documentation. I don't know. That's left to be remain. But what I do know is, heaven forbid I ever get that letter of inquiry, I am prepared. That's what I know. And that's what helps me sleep well tonight. I do screenshots. I print out pages when I can. I show that I went to the zoning. I show that I went to the tax bill and NCDOT. Does that make sense? Because if it ever comes up, there's your documentation. Annette, that was quick. Was that?
Yeah, I had a question. With all your documentation of your material facts, is there going to be a place under your contract to put all of this information, or you're emailing this information to the other agent? I mean, or is it just something oral that you have to write down that I talked to, the seller's agent about it?
I'm gathering my documentation for my records. And if I warrant that I need to send it on to the buyer seller, I will. But when I take a screenshot of this year's tax bill, that's for my records. That goes in my file. And that shows that I took the efforts to look up that tax bill. Now, if the buyer says, what's the tax bill? I can say, here you go, right? Or I can give them the source.
So I don't have to have them actually sign off that they received this information from me. So
Not
later
necessarily.
on,
Not necessarily. But you could choose to take that a step further. We do have things that we require our buyers, as my firm requires our buyers and sellers to initial off on, so there could be things, and it doesn't hurt to have them acknowledge. I mean, even if you just email it to them, you have a time and date stamp in your sent file, right? So even if you just email it to them, you show that you sent it.
okay.
So the big four that revolve around what happens if we're doing material facts wrong. Remember the disciplinary action chart? 45%. 45% of disciplinary action in that year was because of either omission or misrepresentation. When you see a test question, did y'all just hear what I just said? When you see a test question, you're going to get a scenario. And it's going to tell you what the broker did or did not do. It's going to walk you through the scenario. When you see this test question, the first thing I want you to do is ask yourself, did the broker lie or did they omit the material fact? First, ask yourself, is this a misrepresentation or an omission? Once you determine that, go back through the problem and determine if it was done willfully or negligently. Willful acts are going to say things like the broker had actual knowledge, or the broker knew that the crawl space flooded every spring, right? You have that knowledge. Negligent acts, you don't, but you could have found out. Most of your firms, not all of them, but most of your firms are going to carry E&O insurance, errors and omissions. This is like our medical malpractice. Doctors and the medical profession has medical malpractice. If things go wrong, that's not their fault. They're covered under medical malpractice. most of our firms carry E&O insurance. It's not going to cover you for willful acts. But if we can prove that it's negligent, if we can prove that you didn't know, your firm's got your back. Again, all firms are different. They carry different policies, different. Not all firms are required to carry E&O. But to protect the firm, most firms have some kind of E&O insurance. Can they still file a complaint? Can they still hire an attorney? Sure. You can sue anybody for anything, right? How far are you going to get? It depends on the documentation. It depends on what you have that I don't. Like I said, it might just depend on the mood of the judge that day. It could be that sensitive. What I've always heard, you don't want to stand in front of a judge on a Friday afternoon because they're ready to go for the weekend, right? I mean, the judge is human too, and it could just depend on there. So, everything is a case by case story, a case by case situation. See, we've hit on caveat emptor. Caveat emptor, North Carolina is a buyer beware state, which is why sometimes buyers hire agents. Because we have that duty to disclose material facts, not the sellers. Y'all, there's a lot of buyers out there that won't even look at a for sale by owner because the FSBOs don't have that representation and they just don't trust. They just don't trust them. They say, I'm not going to rely on anything a FSBO told me. Now you put a broker involved and it doesn't matter what the seller says. The broker always has that duty to discover and disclose material facts. So regardless of how the seller completes the RPOs, we still have that duty. And once I find out, and I really don't care how you find out, once I find out, I now have that duty to discover and disclose. We hit on a pretty big word looking at the RPOs. We mentioned latent. So let's talk about patent defects versus latent defects. Patent defects are things that are clearly visible. Look, I'm not a structural engineer, so I can't tell you that there's structural problems here. But if you were buying this house, I would highly recommend that you talk to a structural engineer. Did your little red flag just go up? Does this thing look secure? Right? Now, I can't make you do anything, but if you say, Julie, this is my dream house, I don't care. I'm going to document the fact that I encouraged you to talk to a structural engineer. This is a patent. Compare that to something that's latent. Latent is something that's hidden. It's not obvious. If the seller, as we saw in the RPOs, if the seller knows of anything latent, what that means is I'm not going to be able to see it. I'm not even going to get the opportunity for my little red flag to go up because it's latent. It's hidden. There's nothing going on that I can see. That's why in the RPOs, the seller is encouraged to disclose those latent defects. But after closing, when the buyer finds out, if they come after the agent, that's going to launch an investigation. And again, the commission's going to ask, could they have found out? So we are not responsible for latent, hear me, as long as they are truly latent. This doesn't give me an out to bury my head in the sand and be like, nope, don't see anything here. We still have that duty to discover. So is the broker liable for failing to disclose a latent defect? Are we responsible for latent defects? And the short answer to that is nope, because it's hidden. So if my flag didn't go up, I have nothing to disclose. So I can't be liable for failing to disclose latent defects if I perform my visual inspections and I found no obvious defects. Nothing threw a flag out at me. The seller didn't give me any reason to think that they were lying or not truthful. When we go through homes, we have checklists that we can use. There's your documentation. You looked at this, you looked at that room. I'm going to make notes as I go through the home. As we get older, I feel like our little brains get littler and littler, and I'm not remembering as much as what I used to once upon a time ago. I need to take notes when I'm going through the home. I need to take good notes. And I'm going to say something, and many of you find this just downright offensive. I can't believe she just said that. But I'm telling you guys, the voice of experience, after a while, after you see so many of those homes, they all start running together. They all start looking alike. And once you've viewed enough homes, you're going to start questioning, now, which house was that in? So take good notes, you guys. Take good notes. At the end of the day, it's all four walls. And they all start running together. Is that a horrible thing to say? But it is personal experience. I can't tell you. I have the highlights from the homes I've seen. If I could piecemeal all those highlights, I would build my dream home. You know, I want the kitchen from that listing and the bedroom from that one I showed the buyer. But just make sure you take good notes. And again, we have checklists. The MLS gives us an input checklist, so I can go through the home and look for things as I'm trying to find things to comment on when I'm marketing the property. Your firm will probably provide you with a checklist template, which you could customize and make your own in time. So utilize checklists. Keep those checklists with your file, with that transaction file. And you have documentation that you at least took the time to pick up the pen and check something off. Now, they may have some questions for you, but at least you can show that you went through the home. You did that visual inspection. I saw this, I did not see that. And that's why we use checklists. It's a lot. I'm not going to stand here and pretend to you that it's not. Especially if you're working with multiple sellers, multiple buyers. Get organized. It helps. If you're not already, it helps. So we talked about a whole bunch of things that are material facts. So let's switch gears just a bit and talk about things that are not material facts in the state of North Carolina. This may vary from state to state, but things that are not considered a material fact in the state of North Carolina. First, the house where somebody died, maybe the site of a highly publicized murder-suicide, the haunted house on the block. In North Carolina, stigmatized property, a stigmatized property is one that's been branded as by society as undesirable due to the activities that have happened in the home. And in North Carolina, a stigmatized property is not a material fact, which means I don't have to volunteer the information. However, if I'm asked, I still do not have a golden ticket to lie. I don't have to volunteer it. But if I'm asked, I cannot lie. And if this is something of importance to your buyer, some people do not want to purchase a home where somebody passed away in it. And if this is something that's of importance to your buyer, don't you now have a material fact on your hand? Before we go see this property, we're going to call the listing agent. Listen, maybe they can tell us, well, none of these sellers died, none of these owners died, but what about the owners before them and the owners before them and the owners before them? They may just be able to give us information from the current owners, No, nobody died in this house while they were living there. That's information your buyer needs to decide. Google. Google is your friend. Just type in the address. If something happened in this home that made the highlights, made the headlines, it's gonna pop up on Google. Everybody with me? Stigmatized properties, criminal activities, murder, suicide, things like that will pop up on Google, and we can share that with our buyers and let them decide if they want to see it. Let them decide if they want to proceed. And it's really important that you guys understand that this is one of those things that are only specific to North Carolina. Other states determine this is a material fact. Now, I can't tell you which states do and which states don't, doesn't matter. But in North Carolina, it's not a material fact. With that being said, be prepared for buyers from other states coming in here and look at you saying, you have to tell me if somebody died in this home. Nope. In North Carolina, I don't have to volunteer the information. But if I'm asked, I cannot lie. It isn't, I don't know, an honest answer. You've never been in this home before. Now, y'all, we have different beliefs, different opinions. We believe what we want to believe. I know for a fact that I've walked in the front door of at least 2 homes in my career, and those teeny tiny hairs on the back of my neck stood straight up. What's that tell me? I don't want to be there anymore. You can interpret that any way you want. That wouldn't be the house for me. Does that make sense? But what does my opinion matter when my buyer's buying? That's what we got to get to the bottom of them. Now, there's one exception to this. If you're ever asked if anybody in the home has AIDS or HIV, our answer is always federal fair housing prohibits me from answering that. I'm going to say that again. If you're ever asked, did anybody live in this home that had AIDS or HIV? Your answer is federal fair housing prohibits me from answering that, whether you know or you don't. Those with AIDS or HIV are protected under the handicap disability status of federal fair housing that we're getting into in Unit 4. This could be a family member's home, it could be a friend's home, and you know for a fact that nobody had AIDS or HIV. Your answer is always federal fair housing prohibits me from answering that. So again, stigmatized properties, those that have been branded by society as undesirable. In North Carolina, this is not a material fact. Remember, we just said there's a home for every buyer, whether it's or a buyer for every home. That's what I meant to say. There's a buyer for every home, whether it's stigmatized or not. If you claim this home to be haunted, you're going to attract a totally different set of buyers. Some people seek this stuff out. There's a buyer for every home. Another thing not considered a material fact in North Carolina is the presence of registered sex offenders nearby in the neighborhood. When it comes to this, I'm a big fan of being the source of the source. I'm not going to disclose. I don't have to volunteer the information. But this does come up with buyers. It comes up with tenants, because buyers and tenants often come with kids. And if you're ever asked, are there any registered sex offenders nearby? I encourage you to be the source of the source and send them to the North Carolina Sex Offender Registry website. Let them do their own research. We have something called Megan's Law that says convicted sex offenders have to register their current address. Megan's Law, I was told, updates about once a month. So it might be you're looking at Megan's Law or the website, the sex offender registry website, and it hasn't updated yet. But they do have to, convicted sex offenders do have to register their current address. And the other thing your buyers need to be aware, a couple things. First off, that word I'm saying is convicted. If you're charged, you've not been convicted. You're not convicted until that gavel comes down and the judge says guilty. So if you're charged, you're not convicted, you're not going to show up on the registry website. And unfortunately, not all sex offenders have been caught yet, have they? So there's some still out there. So when you say, there's no sex offenders nearby, you don't know that. You don't know that. So let's just be the source of the source and then send them to the sex offender registry website. The word we're looking for here is convicted, and that's who shows up. That's who's required under Megan's Law to update their address. And let your buyers and tenants know too. Sex offenders can and do move. So there may not be one that lives next door today, but that's not stopping one from moving in tomorrow. So how about we're just aware of where our kids are, who they're with, especially in a brand new neighborhood while you're getting ready, while you're meeting your neighbors, right? But let's be the source of the source and send them to North Carolina Sex Offender Registry website. Questions on those, the two things not considered material? Yeah, Brittany.
So you said in North Carolina, these are not considered material facts.
Correct.
So those would be something we would see more on our state exam versus the national, right?
Correct.
Like not, they
Correct.
won't ask us national questions. Okay.
Correct. They're not going to ask you about Virginia. So, yep, this is something just specific to, and again, other states, and I don't know what other states, and that's not, right? If you want to learn about other states, go take their pre-licensing class. Once you get done with mine, one thing at a time. One's enough? Is that what you're saying? All right, you guys, let's go ahead and take our last break. We'll come back. We're going to finish up talking about material facts. Single family, they want our services after we die. No, I'm good. Who wants to do a survey? Do a survey. They're conducting a survey to determine how members of our community plan for one of the hardest things a family can decide. The death of a loved one. And if we do the survey, they're gonna provide us with a complimentary guide. The Final Wishes Organizer. It's just spinning out, so you're good whenever. That one mattress pad is hard, but I always got spinning out. Eliminate driver time.
Thing to do, I'm gonna jump in the shower and
Go.
finish up another return. That'll be my quota for the day, but I'll probably keep going.
Cameras are back on. We're going to take attendance. And before we go back into the discussion, I want to take an attendance now. So you guys are in. I want to introduce you to one of the commission's publications. And I'm in our Google Drive. And in our Google Drive, we have something called License Law and Rule Comments. Brittany, you actually mentioned this earlier, so that did my heart good. So the License Law and Rule Comments. Y'all understand there's license law and there's commission rule. I'm not asking you to read license law. The only commission rule I've asked you to read is 58A.0104 about agency agreements and disclosure. So to supplement the license law and commission rule, what we have is the comments. This is pretty much Unit 15. So I introduce this to you now, knowing it's coming in Unit 15. This is not an easy read. Have y'all ever sat down and tried to read law? Boring. This is not the best read. However, this is Unit 15. This is your state-specific section. So I suggest you guys start now in preparation for Unit 15. And I suggest that you guys break this down into pieces, break this down into sections. Don't try to read it in one sitting. So part of the reason why I introduce this to you now is because we know it's coming, and we know this is mostly our state-specific section, so we know that this is important. Another reason why I introduce this to you guys now, if I just kind of scroll down here, scroll. Once I get to page 4, what are we talking about on page 4? Material facts. So it's another way for you guys to understand material facts. Here's your misrepresentation and omission, the comments, things that are not material facts. And then the comments give us the big 4. So not only do they give us the definition of the big 4, but they also give us examples of the big 4. And I'm a big fan of the examples. I think the examples help determine the big 4. Remember what I told you? Your test question is going to give you a scenario and ask you A, B, C, or D, which are the big 4. So I think the scenarios in some cases are more helpful than sitting there and reading the definition over and over and over again. The examples help you solidify it. It helps you apply it. So I encourage you, and look, there's stuff in here about agency agreements and agency disclosure. There's plenty of stuff in here that we've already talked about. So here's another good piece of good news. By the time we get to Unit 15, we've covered most of it. We've said it or addressed most of it. So Unit 15, if we're following through, if we're going through, Unit 15 can mostly serve as a good refresher. Or if this is brand new information to you, then this is information that we need from our state-specific thing. So please go ahead. And yes, you can find the comments and Learn Test Pass. But again, I don't always find those forms easy to view, easy to read. But I put them in Google Drive. It's a PDF. You guys know your little download button up here. So you can download it and save it, or you can print it out if you want to. It's 22 pages. Just be aware of your printer and the trees. But I do suggest that you guys go ahead and start on the comments. And you may even want to start with what we've covered. So you have an additional source of information to help you better wrap your brains around those material facts and around the big 4, the things that aren't material. And like I said, if we scroll a little bit further, talking about all these things, but check it out. There's agency agreements and disclosure, things that we've already talked about. We're not talking about everything before we get to Unit 15, but much of it just comes up naturally in our discussion. So everybody got that jotted down? I just gave you another to-do on your to-do list, didn't I? And that's why I'm not asking you guys, if you can sit down and read this in one setting and know what you've just read, my hat off to you. Make it easy on yourselves and break it down into sections, break it down into manageable pieces. Fair enough? Questions on that? It's in our Google Drive. License law and rules, and it's the comments. If you don't have access to the Google Drive, send me an email at 2 o'clock. If you don't have access to our YouTube channel, send me an email at 2 o'clock. Don't do it now. I would consider that a distraction. But if you don't have access to these things, send me an email this afternoon and I will get you access. Questions? Hang on. I need to stop sharing just for 1 second. I hit the wrong button and it messed everything up. Let's see if I can't go back and hit the right button. Let's come back and get you guys. Let's try that again. All right. Okay. When it comes to the RPODs and the MOG, what is my responsibility? What am I responsible for? And you can mute, unmute, chat, whatever.
Making sure the seller completes those documents.
Make sure the seller completes them. What else am I responsible for?
Getting them to the buyer.
Facilitating delivery to the buyer. Understand it's the seller's responsibility to provide them with it to the buyer, but you and I can assist with that. The only thing we can't assist with is completing it for them or telling them how to complete it. So my responsibility, I'm going to get the blank form to the seller. I'm going to say, here's your duty to do this. This is what happens if you don't. And then once the seller does, then we're going to aid in delivery to the buyer. Is the seller required to disclose known property defects? And I got you guys shaking your head no. That's kind of the hard part, right? Remember, only the seller can hide behind caveat emptor. Welcome to North Carolina. It is a buyer beware state, and we stand tall and proud behind that. The seller doesn't have to disclose much. We're getting ready to talk about that one thing that the seller does have to disclose. But other than that, it's at their discretion. So are they required to disclose? No, but the broker is. Can a listing broker, ooh, this is a flashback, a throwback. Can the listing broker list lots for sale? Can we advertise lots for sale in a new subdivision? Can we list properties with preliminary information? Yes. I can list it with preliminary.
Can't
I
close.
can put you, that's it. I can put you under contract with preliminary, but we can't close until we have the final. That's the difference in the final plat map covenants, the final information versus the preliminary. I can list it. I can put you under contract with preliminary. I cannot close until we have final. Questions? Last little section in Unit 3, the end is in sight. And we're going to talk about some environmental hazards and what my responsibility is, what the licensee's responsibility is when and if these environmental hazards are discovered. Hint, my responsibility is to disclose what I know. Just summed up that whole section right there. We are also going to talk about those environmental issues, those most common environmental hazards that you very well may come across. So before we get into specifics, let's just understand what we're dealing with here. And any environmental issues got to be disclosed. So once I discover it, it doesn't matter how, maybe somebody tells me, maybe the buyer has an inspection and we learn that information. It doesn't really matter how. But once we learn of any of these environmental issues, then we have that duty to disclose. Environmental issues are considered a material fact. And I have to disclose if the seller believes the cure has been removed or not. Most common with environmental issues, they just don't poof, go away. So there always will be some kind of lingering, some kind of aftermath. So again, if they've ever had an issue, it's been cured or removed, we still need to disclose that. There was an issue, the seller says it's being cured. All I did was disclose what I know. And that's the key, the trick to environmental. Disclose what you know. And then we also have a duty to disclose contamination outside of the property boundaries because it may impact the value. So if the neighbor has had an environmental issue, then we still want to make sure that we disclose that because some of these can actually leak from one home to the next. We're going to talk about that. You know, environmental issues are one of those things that have gotten pretty big in real estate over the last recent years because environmental issues affect people. And you and I are working with the people that are living in these properties, buying or selling or renting these properties. So disclosing what we know, environmental issues are all around us. I mean, they are all around us. But it's just a matter of disclosing what we know so the buyer can decide if they want to take the property with these known issues. Anytime these environmental issues come up, we're going to call a qualified environmental engineer specialist, stay in your lane. The EPA's website, Environmental Protection Agency, EPA, they're sometimes a good place to start. They can help us educate us on some of these environmental issues or educate the parties on some of these environmental issues. And remember, you guys, I'm the expert of my market. So if I know what's going on in my area, then that's going to help my red flag go up for some of these environmental issues. Some are just specific to the property, but others are about the surrounding area, the neighborhood, the community. So because we're the experts of our market, we know where these things may pop up, and now I'm on alert. Like we said, usually a good place to start is the EPA, Environmental Protection Agency. There's guides, there's regulations. It can help educate the consumer. Closing attorney may have some information, but ultimately with any environmental issue, if your buyer's concerned about any of these environmental issues, the best thing that we can do is encourage them to have it tested. For the most part, not always, but for the most part, our home inspectors are really good places to start because either they have the knowledge, the tools, and the expertise to test, or they know who does. So make friends with those home inspectors. Get you a home inspector on speed dial. There's nothing more valuable than having that relationship. So let's talk specifically about what some of these super scary environmental issues are that we may come across in our brokerage activities. And probably one of the bigger ones, one of the ones that comes up most often, is lead, specifically lead-based paint. Once upon a time ago, when we used paint, we had lead in the paint because it was a quicker drying agent. It helped the lead paint dry faster. But then we discovered that there were potential dangers in using lead-based paint, and we banned lead-based paint in 1978. That year's important, and it will be important when it comes to lead-based paint. 1978. So but prior to 1978, we got the heads up that lead might be bad. And in 1978, we stopped building or saying we're going to build with it, use it in our building products. Lead poisoning is most dangerous to young children and women with child. Lead poisoning affects those developing organs, those little developing bodies. Once you're grown, the dangers of lead is like minimal. So where lead is dangerous, what lead affects is our children, those young developing bodies. Nice. Remember when I've been saying the seller doesn't have to disclose much? Here it is, folks. This is the exception. If the seller knows of lead in the home, federal law requires them to disclose. If the seller knows of lead in the home, it's because they've had it tested. Whenever you hire contracted contracted painters, when you're paying professional painters, if the home was built prior to 1978, then they should, under their board, they should have it tested. And once the seller knows of lead in the home, that's the one thing that they have to disclose, because this is a federal law. Federal law will override state caveat emptor. So when I say the seller doesn't have to disclose much, this is the much that I'm referring to. This is the one thing that they do have to disclose. But again, they can only disclose what they know. Has anybody ever painted a room on your own? It's really easy to do, right? Trip to Lowe's and away you go. If you're a do-it-yourselfer, you may not know. You may not have known to have it tested. You may not have known that you should think about having it tested. If you're a do-it-yourselfer, then you may not know. But again, that contracted work, that paying work, should have that tested. When it comes to lead, the year to know is 1978. All residential properties built prior to 1978 is required to have the lead-based paint disclosure. I got a lead-based paint disclosure. In anything built prior to 1978, that disclosure is required. Now, the disclosure does not say your home was built prior to 1978, so it has lead. What the disclosure says is because your home was built prior to 1978, it may have lead. Again, the only way to know for sure is to have it tested. The only way to have it tested, they're going to come in and chip off some of the paint and send it to the lab to have it tested. Painting over lead-based paint doesn't make the lead go away. I mean, think about things built prior to 1978. We're almost 50 years ago, right? It's probably been painted a couple times since then, but that doesn't make the lead go away. If the kid gets to it, then the kid is still possibly suffering from the dangers of lead poisoning. One of the best things we can do for our buyers and tenants, the EPA has provided a booklet called Protect Your Family from Lead in Your Home. And what this is just identifies the potential dangers of lead paint in the home. How can it affect children? How can it be tested? What do these tests mean? This is our education booklet, and this is from EPA. You could either go to EPA's website. Don't worry about it now. You don't need to worry about it until after you're licensed. Many of your firms, we have a PDF version of it. It doesn't matter how you get it to your buyer, but we can get this to our buyer to help educate them, especially those with lead. They say they got it in Learn Test Pass. So it's going to be in the Unit 3 material, but again, just more informational. Don't spend your study time reading the Protect Your Family from Lead in Your Home pamphlet. So the owners have to provide disclosure. The owner has to provide, they have to disclose what they know. The owner is not going to certify that the home is lead free. The owner is not a lead expert. They're not going to tell you that it's lead free or not. They're only going to disclose what they know. The owner is not obligated or required in any way to pay for an inspection. The buyer is welcome to have it inspected before they buy. No requirements. And again, if the seller's a do-it-yourselfer, you paint your own room, you paint your own house, you probably never had it tested, you didn't know to have it tested. The seller can only disclose what they know. And the only way to disclose it is to have it tested. This gets a little bit different when we're talking to tenants. The buyer is welcome to have it inspected, but the tenant cannot, because it's not the tenant's home, nor is it going to be. However, with that being said, the landlord needs to disclose what they know. So if there's any potential for lead, if the landlord owner knows of lead in the home, then they've got to disclose that. So there's no laws out there that require anybody to have it tested. Is everybody hearing me? There's no laws out there that require an owner to have it tested. However, if they do, and they discover there's lead in the home, they now have the one thing that the seller has to disclose. And don't forget our duty to discover and disclose material facts as well. So you're getting ready to list a property that was built in 1975. Did your little red flag just go up to ask some questions? Encourage you to ask the seller, have you ever had this tested? Did you get any reports? What did you find out? So there's your little red flag. Anything built prior to 1978, and you need to know that year for your exams. So lead-based paint remedies. Yes, ma'am, Ebony.
So, I know we're dealing with residential, but does that also apply as far as like commercial with buildings, like schools and things like that, or?
Nope, just residential for lead-based paint. Yep.
Okay.
Yep. And some residential properties are exempt from the Lead-Based Paint Act. Like, for example, homes for the elderly where kids don't live there, right? So you got like a retirement or nursing home or something like that. Kids don't live there, so they're not required. They don't have those same disclosures, those same. It's about the kids. And if the kids are going to live there, that's where we need to educate. Yep. So the North Carolina lead-based paint remediation, you could get a certificate saying that it's been remediated. Could you sue after coming in contact? Again, you can sue anybody for anything. So the question the judge is going to ask the seller is, did you know? Did you have it tested? And if the seller says, I never had it tested, then you're not going to get far in that lawsuit. Does that make sense? They can only disclose what they know. Can you sue? You find an attorney out there? Absolutely. You sue anybody for anything. I remember a couple years ago, somebody sued Texas Pete because they found out it wasn't made in Texas. You can sue anybody for anything, right? How far are you going to get? It depends on your attorney. It depends on the leg that you have. It depends on what you have to stand on. Yes, Annette.
Okay, so how do I want to phrase this? So the owner has to sign a disclosure form, but they don't have to actually have it tested.
Correct.
They just have to sign saying that, it was built before 1978 and that you're aware that the lead is there. It's
All it says is the owner does or does not know of the presence of lead in the home. So the owner does or does not know. And if they do, then they are suggested that they provide the reports, the proof that they know. But
And
they
that's-
have the option to say, no, I don't know. And if they don't know, they don't know.
and that's the only thing that the owner is not protected under.
Caveat emptor does not, right.
Just
So
wanted-
lead-based paint laws are federal laws, caveat emptor state. So when we say the seller doesn't have to disclose much, this is the thing that the seller has to disclose.
And that's only if they're aware.
They can only disclose what they know. Yep.
Okay. All right.
Again, don't get excited because the home was built prior to 1978. Is there a good chance there's lead in it? Especially if you go back to like the 40s, the 50s, right? Especially you go back, yeah, there's a good chance. But the only way to know for sure is to have it tested. So back to these professionals, and by professionals, I mean those that are paid contracting work to help to work with lead in the home. That certification requirement for remediation. Gee, Julie, what's the big deal? Well, failure to properly follow federal lead-based paint rules could result in the contracting work having daily fines. So what happens if they don't test, if they choose not to test? It's not a problem until it's a problem. And if the contracted work doesn't have it tested, they could be facing daily state and federal fines. And remember, owner occupied, if you're a do-it-yourselfer, you may have it tested, you may not know to. You may have no clue. The key to this, the owner can only disclose what they know, and the only way to know for sure is to have it tested. You can do it, the contracted work can do it, or not. Where are my HGTV fans? I know you guys are out there. Where are my HGTV fans? Y'all are laughing. I know, you just called yourself out, right? Y'all know Chip and Joanna? They got themselves in trouble for this a couple years ago. Anybody remember this? They got themselves in trouble because they failed to disclose the presence of lead in the home. So guys, these rules even apply to our reality stars, right? And I don't know, they had to pay a fine. I can't get into specifics. You're welcome to Google it at 2 o'clock. But that made it very, very real. That made it very, very real. They didn't follow the federal guide. And again, I don't know the specifics, but what I do know is they didn't follow. They're back at it, but there were consequences to those actions. And you know, they learned a big lesson. Lead does not cause cancer. Lead doesn't affect adults. Lead is about those kids, those little developing organs. Another environmental concern is radon. Radon is the byproduct of decaying matters in the ground. So when things in the ground are decaying, it's releasing this radon gas. The radon gas is looking for an escape through a crack in the ground. And if the crack on the ground happens to be underneath the home, then there's a good chance that that radon gas can seep into the home. Maybe it's a well, maybe it's a crack underneath the slab or the crawl space. The remedy to radon is a mitigation system. And the mitigation system pretty much, it drills into the lowest level of the home. And then it has this pipe usually that runs up the side of the home and pulls this air out of the home, pushes it up through the pipe out to the atmosphere where radon gas belongs anywhere. Radon is one of those things that's very local. You may not have any radon issues, but your neighbor might. So it's suggested that all buyers are encouraged to test for radon. The radon test. Your home inspectors can often help with this. And they bring this little contraction into the home. And the contraction takes like a snapshot of the radon level every hour. So what's the radon level this hour, next hour, next hour? And that contraction is in the home for about 2 to 3 days. And at the end of that time, they come back and get the contraction, and then they pull a report for an average, a cumulative of those hour tests. If the radon level is 4.0 picocuries or more, we now have a material fact on our hand. If the radon level comes back at 4.0 picocuries or more, one way to help with radon gas is ventilation. Occupied homes may not have as high levels of radon as vacant homes. Vacant homes don't have the doors and windows opening up regularly. They don't have the AC and the heat kicking on. They don't have the ventilation that an occupied home generally has. But even an occupied home can suffer from radon. So your buyer's under contract. You suggest to your buyers part of their inspections that they have a radon test. The radon test comes back, I don't care, pick a number, 6.0 picocuries. Higher than 4.0, right? We got a material fact on our hand. As part of the buyer's inspection process, they ask the seller to put in the mitigation system. Is the seller required to repair anything? Do they have to fix anything? No. So it's up to the seller if they want to put in the radon mitigation system or not. They don't have to. It's all part of the negotiation. But listing agents, you need to let your seller understand that if this buyer chooses to terminate because you're not going to do this radon mitigation system and we go back on the market, don't I now have a material fact on my hand? Don't I, as the listing agent, have a duty to disclose? And guys, let your seller know that 6.5 picocuries is going to come up with the next buyer. It's not going to go away. So they may be encouraged to put in the mitigation system or negotiate something otherwise. But they need to understand that if this buyer terminates and we go back on the market, we're going back on the market with a material fact because I now know that the radon level is 6.5 picocuries. Radon causes lung cancer. The radon gas, you can't smell it, you can't taste it, you can't see it. You breathe it in, that gas gets in your lungs, causes respiratory issues, lung cancer. There's commercials out there, and y'all bear with me, I never get this word right, but there's commercials out there from those attorneys talking about if you or a loved one suffer from mesothelioma. Is that close enough? You guys know what I'm talking about? These are people that have had extended exposure to radon gas. Those are the ones suffering from, there it is again, mesothelioma or something like that. You know that big word? Those are the ones suffering, the ones that have had extended exposure to radon gas. If you go down east to the coast, the ground is sand. It's a lot softer. Radon can absorb differently. You may not have as much radon down east versus going up to the mountains where now it's all rock, it's all hard. So the topography, the type of land that you're on may affect it, but again, radon gas is everywhere. Even if you bought a home and you had it tested when you bought 3 years, 5 years, 10 years ago, you may want to consider having it tested every 5 years or so, because it may not have radon gas there today, but that doesn't mean things can't start decaying in the ground tomorrow. You can get radon tests at like Lowe's, Home Depot. I've had home inspectors tell me that they're a good start. So you may want to start there, test your home for radon. If you're concerned, that's when you call in the radon specialist. Questions on radon? Another environmental issue you might come across is asbestos. Asbestos is banned. We're not building with it anymore. Again, 1978, but that year's not important when it comes to asbestos, just when it comes to lead. But anything built prior to 1978 may have asbestos, and it was once used as an insulation or a fire retardant. So you might see it on siding, insulation, maybe popcorn ceilings, various flooring. And the deal with asbestos, as long as it's intact, it's fine, no problem. The problem with asbestos is when it becomes friable. When it becomes friable, those little particles of the insulation are breaking down. They're getting in the air. We breathe the air. So those little particles get into our lungs. So once again, we're dealing with respiratory issues. Extended exposure could lead to lung cancer. So again, the mere presence of asbestos is nothing to get excited about. It's a health hazard when it's friable. If you're helping your buyer buy an older home, something built prior to 1978, of course, we're on the lookout for them to, and they always encourage them to have it tested or inspected. But especially if your buyer's talking about doing major renovations or demolition, that asbestos needs to be treated and handled by the experts before the wrecking ball shows up. So we can go to the EPA's website, help them get information on how to proceed with that. Again, home inspectors can often tell us more about asbestos, and if it's something that we need to look into further or not. Questions on asbestos? Another thing that you will find everywhere, even in your own home, mold. Mold's everywhere. Y'all take a big deep breath with me. You just inhaled some kind of mold spore. It's everywhere, right? It's everywhere. Mold can range from the mold on that loaf of bread you've had too long, the whole way up to black toxic mold and thousands of strands in between. Mold starts by moisture. Mold doesn't need much. A little bit of moisture, a little bit of oxygen, and that's all the mold needs to grow. I'm not a mold expert, so I can't tell you what type of mold this home has. The only thing we can do is encourage our buyers to have it tested. Have you guys ever, and if you haven't, you will once you get out and start showing property, gone into an unfinished basement and thought to yourself, this smells basement-y? All right, there's no odor called basement-y. You're smelling some kind of mold or mildew. You're smelling some kind of mold or mildew spores. What is it? I don't know because I'm not the mold expert. But when I walk into that unfinished basement and I smell something that smells basement-y, my little red flag just went up.
That goes for like a brand new like basement need.
Oh
It
yeah,
doesn't matter.
all you need is a little bit of moisture and a little bit of oxygen
Okay.
and mold. It doesn't take it long. It's actually a little impressive how little it needs to grow, to take over. Yes, ma'am, Brittany.
Okay, so in the book, it says nationally, the seller must disclose the mold presence in the house. So when we're taking the
Yep.
national portion, we know that it's been tested and has to be disclosed, or it just at any point has to be disclosed.
So the North Carolina Real Estate Commission, who we care about, and the Real Estate Commission says mold is not a material fact because it's everywhere. And if we were going to disclose mold, we'd be disclosing all properties have some kind of mold. So the Real Estate Commission doesn't consider it a material fact unless it's in an excessive amount. And that's when we can see it, when we can smell it. And at that point, if we're seeing it and smelling it, the disclosure is just a formality, isn't it? Because buyers are going to see it and smell it. Sellers or, buyers agents. So guys, when we talk about when you walk into a home, we need to be smelling. We need to be looking. What you're looking at, I would consider that excessive. If I ever saw that, I would get out of that house pretty quickly because I don't know what strand it is. But yes, if it's an excessive amount, it needs to be disclosed.
So I think my question is it going to be both on nationally and state tested? Okay.
Could be.
Okay.
Could be.
Thank
Yep.
you.
Yep. We had a listing once, and it was an estate. The aunt or the woman passed away, and evidently the only family member she had was her nephew. So unbeknownst to her nephew, she left him with this property, this home. And the aunt had a whole lot of fun in this home, and she left the nephew with a mess. And the nephew called us and said, I don't want to deal with this. Can you just sell this house? I'm ready to be done. Not all estates are a gift. And this is an example of one that was a challenge. The aunt lived hard. I think just by looking at the house, the aunt enjoyed life. She liked to party every once in a while. And now the nephew was left with the aftermath. We got under contract, y'all. We advertised this thing as a diamond in the rough, right? We got under contract and the buyer had their home inspection. And the home inspector to this day would still probably deny it. But the next time somebody went into that home, the air conditioning had been turned down to and left on 55 degrees. And that AC running, all that moisture, all that condensation. The next time we went to the home, there was mold on the walls, the ceiling, the floor. That former party house just got worse, just like that. It was baffling how fast it happened. And the home inspector denied it, of course. We live and we learn, right? You know what my team does now whenever we have a home inspection on a vacant property? We go after the home inspector and make sure that it was shut down. You live and you learn. And that was a lesson learned. And yes, we did sell the home. Again, there's a buyer for every property. It's just the one that's not afraid to take on or find somebody to take it on. You're not going to be able to show up with a bottle of bleach, chicka, 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 and let the mold go away. It just doesn't work that way. So we got the experts involved. Again, mold causes respiratory issues because we breathe in those mold spores. And extended use, extended periods of time can cause respiratory issues. A couple other super scary things out there, environmental issues. Carbon monoxide, specifically carbon monoxide poisoning. Carbon monoxide is the byproduct of incomplete combustion or incomplete connection. So it's releasing those odorless sightless. You can't see it, you can't hear it, you can't smell it. The only way to know if there's carbon monoxide poisoning is to have a carbon monoxide detector. I want you guys to make a personal note for you, for your home. If you don't have a carbon monoxide detector, oftentimes they can be conjoined with our smoke detectors. Because guys, unfortunately, if the carbon monoxide isn't detected, this is often referred to as the silent killer. Families go to bed that night and they just don't wake up. So y'all make your personal note to go get you a carbon monoxide detector, because that's the only way. If that thing goes off, get out. Again, carbon monoxide poisoning is something we breathe in. This one, it like shrinks our blood cells. So it shrinks the ability of the blood to throw through the body. And that's why people just don't wake up. Formaldehyde can be found in products treated lumber. It also is often found in products of our furniture. The glue that puts furniture together can often have formaldehyde. Once upon a time ago, they banned formaldehyde, but since then it's been reduced to a warning. The evidence that it causes cancer is inconclusive. So today, formaldehyde is a warning, which means if you buy furniture, you're probably buying it with a warning sticker on it. This may have formaldehyde. Again, the key is ventilation. Keep those ceiling fans on. Keep the heat and the AC on. Open the windows every once in a while. Allow things to breathe. And then another environmental issue we've already talked about is our meth labs. Again, that when that meth cooks, it sinks into the walls, floors, ceilings. And it kind of stays there. All of this kind of falls back to the air that we breathe. Those respiratory issues. Change your furnace filters every once in a while. Have a schedule to change your furnace filters. Another environmental concern. Another environmental concern is something called brownfields. Brownfields is about the land. Once upon a time ago, there was a warehouse or an industrial plant on this land that leaked some kind of contaminant. Maybe it was an oil, maybe it was something they used in their building products. And even though the structure may be gone, the soil is still contaminated, might be contaminated. I had an agent last year that listed, did he list it or did he help his buyer? I don't know. We were part of a transaction just last year, y'all, around Old Salem. Where are my Winston-Salem people? It was awfully close to the visitor center there. And they disclosed that across the street from that condo or townhome, once upon a time ago, used to be an industrial plant. And the land had been tested, it had been contaminated. So even though that plant was long gone, it's still the soil that's polluted. And that was a material fact that we disclosed to the buyer. They bought anyway. Again, I'm not saying don't buy this house, it's buy a brownfield. I'm just letting you know the information so you can decide how you want to proceed. So I hope this buyer spent some time learning more about brownfields, educating themselves before they made that decision to move forward. Another environmental issue is our landfills. Landfills are either enormous holes that were there, maybe a former quarry project, or they might be built for the purposes of landfills. They're generally lined or addressed in a way. Drainage is a big problem with landfills. Can we just call it garbage juice? And we don't want the garbage juice to soak into the soil. So the drainage with landfills is addressed. These things are highly regulated, federal regulations, state regulations, local regulations. Remember, when you're helping a buyer buy, we're helping them learn, we're helping them discover about where they're considering buying. And another useful, as we've mentioned, another useful tool that we have is Google, because that allows us to see, are there any landfills nearby? Is there anything, maybe not right here, but y'all, let me tell you something. If you live near a landfill, when you walk outside on a hot August day, you kind of smell landfill, don't you? Right? It doesn't always smell good. And that's why we need to let the buyers know if they're in close proximity to the landfills. That's a decision for them to make. So use Google Maps. Use those resources. Hey, it looks like there's a landfill 2 miles down the road. How do you feel about that? Help them learn about the property and the surrounding areas. Questions? So I have a little bit more to say in environmental issues, but I'm going to stop here for today. So Thursday, we're going to wrap up 3. We are almost done with 3. I only got like 2 or 3 more things to say. So Thursday, we're going to finish 3. Then we're going to go on and do unit 4. We're going to do unit 5. And we're probably going to get started on unit 6. Forward we go. Guys, please remember, after unit 6 is when your midterm is going to be available. You have to attempt the midterm. You don't have to pass it, but you have to attempt it. And you guys will be ready for your midterm next week. So you may want to start preparing for that. I've given you about a week's notice, but it was whenever we're done with unit 6 is when your midterm will be available. We'll talk about that, what that looks like in the specifics. But I just wanted to throw it out there to remind you guys that it's coming. And if you want to be eligible for the end of class exam, I need you to attempt the midterm. So we'll talk about that next week. But it's coming and it'll be here before we know it. Questions, comments, concerns?
So is the midterm like a pre end of course testing?
It's going to cover units 1 through 6. So
To
it's
1
going
through
to kind
6.
of
Okay.
your checkpoint. It's going to be your checkpoint on
Okay.
if you were to
Got
take
it.
the end of class exam right now, how would you do? 1 through 6. Anything else? Y'all, go outside and play. Go do something fun this afternoon in the sunshine. Y'all have a good afternoon. Have a great day tomorrow. We'll do it again Thursday morning.